Morning. Today is February 5th, 2026. We are here for the unfair labor practice matter, docket number 2550. My name is David Boulanger. I'll be chair today. With me on my right is Gwenna Peters, a VLRB board member, and in the upper left of the screen depicted is Michelle Phelps, who is also a board member and who is with us remotely. Recording's fine?
Yes.
All right. And could we have the parties introduce themselves, beginning with the union?
Good morning. My name is Alfred Gordon O'Connell. I use he, him pronouns, and I am counsel for the VSEA.
I'm Catherine Terrell, and I'm counsel for the VSEA. I use she, her pronouns.
Good morning, Chris Florian with the Attorney General's office. I use they, them.
Wendy Chen with the Attorney General's office, representing the state, she, her pronouns.
Thank you. Just a reminder, since we are recording and since there's some sort of air handling system going on behind me, I'm not sure about where you are, it's important that we all speak up so that we're recorded, so that we can hear each other and give our full attention to the matter at hand. Are there any preliminary matters that need to be dealt with before we begin? The matter of exhibits that were stipulated to, I understand that there have been some changes. Are there any further changes that we should share with each other before we begin?
The union had previously indicated reserving its rights with regard to exhibits Y and Z. The union has no objection to the admission of those documents.
Thank you. That leaves exhibit HH still as a matter between us. Any other matters regarding stipulation of exhibits? There's no A there. 10A through 10L, 40 through 43, 46, 47, 50, 53, and 57. Yes?
That's correct.
Correct. Opening statements. The union.
Yes, thank you. And good morning, members of the board and council and those participating here and remotely. This case begins and ends with the question as to whether the state violated the State Employees Labor Relations Act by making a unilateral change in conditions of employment as relates to telework, which starts with the premise that telework is a mandatory subject of bargaining. I'm sure this matter will be fully briefed to you, but the National Labor Relations Board, on which the state statutes were based, has found in the Goddard College case that telework is a mandatory subject of bargaining. And the state, through its actions, has indicated that it also agrees that teleworking is a mandatory subject of bargaining, because this story in this case starts back in 2011 when the state sought to implement a telework policy and immediately came to the VSEA and asked the union to negotiate. There is evidence in the record in states exhibits A through H of the communications between the parties, the negotiations over the subject matter, the modifications that were made as a result of VSEA proposals, and the ultimate announcement by press release from the VSEA that we had reached agreement and the policy was on its way to the membership. So that happened back in 2012. There are three pillars of that particular negotiated policy that we'll point out to you today repeatedly, because those three pillars have been fundamentally altered by the state in a way without negotiating with the union. And that forms the basis of our claim here. So the first pillar we'll point to your attention is that the original telework policy, as agreed to by the parties, was a matter of local control. Every decision was made by a local supervisor based on a consideration of the employee's circumstances and was approved by the appointing authority. There was no statewide interference. There was no state policy or state procedure that one had to go through. You merely filled out your telework form, gave it to your supervisor who approved it or denied it, and then it went on to the appointing authority. So local control was a fundamental aspect of the negotiated policy. The second fundamental aspect is that determinations were made case by case based on whether the employee could telework within the operating needs of the department. There was no statewide analysis. It was a case-by-case determination. And it seems obvious that certain employees will not be able to telework at all. If you are a correctional officer, you cannot telework. If you work in a hospital setting, inpatient care, you cannot telework. And there are countless examples. Sworn law enforcement officers who interact out in the public, buildings and grounds personnel who take care of the buildings that we work in and day out. All of these folks have to work in person and could never telework. But for everyone else, they got an individualized determination as to whether they could telework. And the third pillar, which is also sort of pulled together in that overarching theme, is that there were no arbitrary restrictions on the number of days that an employee could telework. The policy itself permitted telework up to 5 days a week. The policy did not have a limitation in it. The form did not have a limitation on it. And as you'll see as we get through the facts of this case, the far majority of the people who were teleworking ultimately teleworked well beyond the arbitrary 2-day telework limitation imposed by the governor. So those three pillars, local control and decision, case-by-case analysis of the employee's circumstances without any arbitrary restrictions on the number of days that could be teleworked. That was the policy agreed to in 2012. What happened next is a matter of import and interest to the board, is that on January 1st, 2014, our legislature passed and the governor signed and went into effect the Flexible Working Arrangement Statute. The Flexible Working Arrangement Statute, which is codified 21 Vermont statutes, annotated section 309, adds to the paradigm of telework in that it requires a good faith consideration of every employee's request for telework on a case-by-case basis, keeping in mind the determination as to whether the employee's work or the telework would interfere with business operations. That's now the paradigm. That is a statutory requirement, a good faith determination, case by case, with regard to consistency with business operations. The statute does not ask whether the employee has any compelling reasons to want to telework. There is a right to telework unless there is some inconsistency with business operations. So that is something that rests on top of the negotiated policy. So as we think forward from 2012 and 2014, the state, VSEA, the legislature, they were prescient. None of us had any idea what would happen in 2020. But the fact that telework existed and policies existed and a statute existed made life a little easier when in March of 2020, the governor issued executive orders shutting down pretty much all in-person contact in the state, except as was necessary, meaning that the far majority of state employees would now have to work remotely if they could. So as of March 2020, COVID pandemic, it turned the world on its head. We have testimony from Commissioner Fastigi from the Human Resources in evidence. It's State's Exhibit Z. It's a presentation she made to the legislature where she indicated that prior to the COVID pandemic, less than 20% of state employees did any telework at all. We just weren't used to it. We all came from a time and a place where you got up in the morning and you got in your vehicle or in public transport and you went to your office, and that's what we were used to. Less than 20% of employees teleworked prior to COVID. Less than 10% of people who teleworked more than one day. So that means more than 90% of people were in the office at least 4 days a week prior to the COVID pandemic. And then the world turned on its head. Everyone learned how to work from their homes to the extent that they could. We are grateful for the hard work and the danger that the in-person continuing workforce had to put themselves through every day. The law enforcement personnel, the corrections officers, the hospital personnel, the buildings and grounds crews who came in every day during the pandemic and put themselves at risk. But there was such a large swath of other state employees who could work from home that they became used to it over the course of a year and a half or 2 years and enjoyed what were the benefits of that. And again, the benefits were again testified to by Commissioner Fastigi before the legislative committee. So according to Commissioner Fastigi, in May of 2023, so this is now a year plus after the height of the pandemic has ended, after the governor has ended the emergency stay-at-home protocols. At that juncture, 44% of state employees teleworked in some respect. 44%. Of those, the average was 3.5 days a week of telework. Indeed, according to Commissioner Fastigi's own numbers, 82% of those teleworkers were working more than 2 days per week at home. Keep that in mind, because when we talk about the restrictions that are currently in place, that means 82% of the teleworking workforce, more than 2,000 people, had their conditions of employment upended by the unilateral change that we're going to talk about in just a few minutes. More than 2,000 employees had their lives turned upside down without negotiating with their union based on these numbers. Another interesting piece of evidence before you is, again, a state piece of evidence. It's Exhibit YY, which contains a list of thousands of employees who had signed telework agreements prior to the change in conditions of employment here. And I urge you not to read all 200 pages of that document, but to pore over that document to see how few people were actually teleworking only 8 or 16 hours. Most of those people were teleworking at least more than 16 hours. And it's very clear. As a matter of fact, the state also gave you some example employees who had telework agreements. Those are exhibits ZZ through OOO. And the far majority of those employees were also teleworking more than 2 days per week. So that is where we were as of October of 2024. Then something happened in October 2024 in that the Economic Services Division of the Department for Children and Families made a determination that a segment of its workforce should no longer be teleworking, that they should be returned to their in-person duty location. When the union got that notice, I will make a tangent to say that the union actually never got that notice. The union got a copy of an email from Deputy Commissioner Miranda Gray that was sent to the members without having been sent to the union. But putting that aside, when the union became aware of what had happened, it became upset that it wasn't involved in the conversation, and it challenged Deputy Commissioner Gray and Commissioner Winters to prove to the union what the underlying concerns were. Why did these hardworking employees have to be returned to their work location to undergo long round-trip commutes every day? What was the reason? Why are we putting all those cars on the road? Why are we wasting all of the time of these individuals to be commuting? Why are we dealing with the environmental impact? Why are we dealing with the low level of parking at the state facilities where they're going to be working? Why are we dealing with all of that? Tell us, Commissioner, what is the rationale? Took a while. We asked for it in October. In February, we got the data, but there was data. We put in evidence before you today we will put in exhibit 10A through 10L. The state is for some reason objecting to the information that it provided to the union during the ESD process. We put in the information that the state supplied to us, showing that there was a raft of constituent complaints about the inability to get service from this group of employees during that period of time. There were 3 voice memos that we will put in evidence. There were about 100 pages of constituent complaints and emails from legislators, state legislators, from Senator Sanders' office, complaining to DCF and ESD that constituent services was failing. ESD made the determination that those employees had to come back into the office to surmount that challenge. VSEA does not believe that the telework was causing any service deficiencies. It might be helpful if the governor would just, I don't know, have appropriate staffing levels. Maybe that's how we could get all of our constituents served, if the governor would hire the people necessary to do the work. But putting that aside, with the then existing workforce, ESD, based on this raft of information about dropped phone calls and the inability to get quick service at an in-person location, determined that this small group of employees had to return to work. The VSEA met with the state. Our non-management unit bargaining team went and sat down with state representatives. When all of those meetings were done, the union had a decision to make. Is there an issue here that we are going to challenge? And if you remember the pillars that we talked about at the outset of the telework policy that the parties had agreed upon, unfortunately, the ESD circumstance met those pillars. It was a one work group, so it was not a change wrought to the entire workforce of the state. It was made locally by the deputy commissioner and the commissioner, the appointing authority, based on their own determinations. And even though we disagree with the rationales that supported this decision, the information is there. We cannot say that the state or ESD was operating in bad faith when they called everyone back in, because we know that they had hundreds of pages of information supporting a problem. We disagree with their analysis, but ultimately the VSEA determined that the state was in compliance with the original telework agreement, and there was no charge to follow. That's the last thing that happened before August 7th, 2025, when in a press release, the governor surprised everyone, including his own leadership team, by saying all Vermont state workers were coming back to work. I believe in that press conference, he said they were coming back 5 days a week. Every worker in the office, every day, returning to commute, every single day. That was different. Over the ensuing months, information started to eke out as to how this was going to happen and what the parameters were going to be. It took until August 28th, 21 days later, for the state to even decide it was going to be a 3-day week commuting requirement, that people could still telework 2 days, but 3 days a week they would have to commute to their offices. So it took 21 days to get that far. And yet there was still no information about how it was going to be accomplished. It took until August 28th for the state to come up with its arbitrary December 1st deadline. We have been asking repeatedly why December 1st was required. The state has never answered as to what exigency required the December 1st deadline. That informs the ultimate decision of the board. So as we watch the dribs and drabs of information come out, I will note that at this point, the state has not even given the VSEA official notice or an opportunity to bargain. The Secretary of Administration called Steve Howard, the executive director, to indicate that she was going to start putting out some information. But the VSEA didn't get notice until September 12th. After this 3-day-a-week requirement was announced, after the December 1st arbitrary deadline was announced, before any other actual information about how the process was going to work was even put on paper, we got notice. VSEA was a bit hamstrung at the moment because we still didn't have any information about how the process was going to work. In fact, Secretary Clark's ongoing emails to the state employees kept saying, we'll have more information soon. So the union, without really any information, is trying to figure out its path forward, ultimately responds to the state by asking to meet. The state had offered to meet. Notably, they did not offer to bargain. They offered to discuss. We took them up on their opportunity to discuss because we just couldn't wait any longer. We could not wait for any more time to go by for the state to actually give us a policy that we could look at, or a proposal that we could look at, aside from 3 days commuting December 1st. So we asked to meet. I'm sure you know a number of lawyers, and I'm sure you understand that two busy lawyers trying to get into the same room at the same time takes a while. October 10th, we finally found a date that worked, and we sat down and met. And in that meeting, the VSEA was shocked at the lack of information that the senior leadership from the state had to offer. It was shocking. We asked pertinent questions. What was the information the governor was relying on when he decided to bring people back to the commuting pattern? What was the data he was relying on? What were the concerns that he had? Were there any studies that he had commissioned? The answer was, we are not aware of any. Here we are in mid-October, literally 2 months, more than 2 months after the governor blurted out that everyone's coming back to work and their offices every single day. They're going to have to commute every single day. Luckily that changed, but more than 2 months since the governor said that, his leadership team had no idea why, had no clue. So after that October 10th meeting, still watching the dribs and drabs of information come through. Interestingly, within about a week or so, seeing the state come out with a exceptions policy to the hybrid work. So for those who didn't want to commute at least 3 days a week, they could ask for an exception, but only under compelling circumstances. At that juncture, the union looked at the pillars that had been agreed upon back in 2012. What are those pillars? No longer is this an employee by employee consideration. It is a statewide mandate. That's a change. No longer is it local control over the decision. There are now new layers to this decision. Instead of the supervisor and the appointing authority making this determination, the human resources manager has to sign off on an exception. The exceptions review team, whoever the heck that is, has to sign off on that exception. And the Secretary of Administration herself has to be involved in that. We are so far beyond the local control that the union agreed to in 2012 that it's not even funny. And the most pressing fundamental pillar that has now crumbled is that in the original policy that the union agreed to, there was no arbitrary restriction on the number of days that a person could telecommute. And now that number is 2 days. You can only telecommute 2 days unless you have some compelling reason. That is a strict, strong change in conditions of employment. That fundamentally alters the agreement the parties reached in 2012, and the state did not negotiate over that. We demanded that the state negotiate. The state bluntly refused, saying we are in compliance with our original telework agreement. I have just explained to you why that is not true. It is not local control. It is not up to 5 days a week telecommuting. It is not a case-by-case analysis by employee. It is a mandate from the governor without any data, without any information, that he wants everybody to commute to their office 3 days a week. Even though there's not enough office space, there's definitely not enough parking, there's no public transportation, we've got environmental impacts, parking impacts, impacts on people's lives. It goes on and on. You will see examples in the record of employees who had been hired during the pandemic and after the pandemic who live out of state. They were hired knowing that they lived out of state, and now they have until June 1st of this year to come back from Texas or Washington State or wherever they are. It's shocking that the state would cavalierly upend the lives of, at that point, changing the conditions of employment of about 2,500 people in clear contravention of an agreement that the parties had reached without agreeing to negotiate with the union. And that is why, members of the board, we are sitting before you today. And that is why I can barely hide the anger in my voice. We submit that by failing and refusing to bargain over this significant change in working conditions, that is a mandatory subject of bargaining, that the state has violated Section 5(1) of Section 961. We are asking that this board find that violation, order the state to return to the status quo ante, put the conditions of employment back the way they were, and if they would like to make this change, they can ask the union. And we can sit down and bargain. Or not, because we're going to be midterm at that point. We'll see how that goes, but we'll see. At the very least, they have to come to the state. The state has to come to the VSEA. The state has to give us notice and an opportunity to bargain prior to making such a fundamental change in conditions of employment. We submit that the facts are as clear as can be. We appreciate your expedited attention to this matter, and we look forward to presenting our proofs. Thank you very much.
Thank you. For the state of Vermont.
Thank you. Fundamentally, this case is about process. Throughout the case, you're going to hear a lot about the return to office in 2025 and the hybrid work standard. And those are polarizing topics. People have strong opinions about them. But this case is not about the merits of return to office. Instead, it's about whether the state was required to engage in midterm bargaining before beginning its 2025 return to office, given that the return to office was implemented under an existing bargain for telework policy that has been in effect since 2012. Policy that gave the state sole discretion to approve or deny telework for its employees. So as you hear evidence that explains the 2025 return to office, as well as background on the state's implementation of telework since 2012. That evidence is needed so that you will have a complete picture when evaluating whether midterm bargaining was required as part of the process in this case. To help you understand the state's case, I would like to offer you a roadmap. Ultimately, VSEA's claim is that the state committed an unfair labor practice by not engaging in midterm bargaining in this case. And VSEA has the burden of proof, and it cannot meet that burden. The state's evidence will rebut VSEA's argument in three ways. First, it will show that the relevant issues were previously bargained in a 2012 policy that was a celebrated collaboration between VSEA and the state. Second, the state's evidence will show that the unfair labor practice charge is in fact untimely because VSEA was on notice in 2024 that the state had determined that further bargaining of this issue was not required. And for the same reason, the evidence will show that VSEA waived its opportunity to search this claim. Throughout this case, you'll also hear reference to the Flexible Working Arrangements Act. You heard it in VSEA's opening. It's a law that protects an employee's right to ask for flexible working arrangements. It went into effect in 2014. And you will hear how the 2012 policy conformed with the requirements of that act and how that act didn't really change the state of telework within for state employees. To give you a preview, the state will be presenting testimony from 3 witnesses, perhaps more, depending on how the case proceeds. The first will be Deputy Secretary Sean Brown, who's sitting at the table with us today. Even though VSEA has the burden in this case, you'll hear from him testifying today due to scheduling needs. And we expect that from him, you'll hear detailed information on the state's use of telework over the past 14 years since 2012. You'll hear why that policy was needed in the first place. We'll look at the details of the policy itself and how that policy was implemented after it was finalized. Then we'll turn to the COVID pandemic. the need for an urgent action and how, of course, that included expanded use of the telework policy, deferring some of the documentation requirements associated with that policy so that that urgent action could be taken. And we'll look at some of the guidance that was issued by the state to implement those COVID protocols. We'll then turn to how the state dealt with the situation when the COVID pandemic began to recede. That includes resuming the use of the telework form to document telework by its employees. And you'll hear from this Deputy Secretary Brown about the context of that as the state dealt with episodes of catastrophic flooding affecting its facilities. And then we'll zoom in to events at a specific department, the Department for Children and Families, where you'll hear about the Economic Services Division suspension of telework in late 2024. And you'll hear about the context surrounding those events. And then, of course, we will turn to the 2025 return to office and what the hybrid work standard entails and how the 2025 return to office connects back to that 2012 telework policy. And we'll look at how exceptions to the hybrid work standard are handled within the state under the current return to office. Later on in the case, of course, VSEA will present its case first. Once you hear from the state again, we expect to provide you with testimony from one of two individuals with the Department of Human Resources who were responsible for tracking telework agreements that were submitted to DHR after the COVID pandemic. And you'll hear what their data shows and what their records show. And then, of course, you'll hear from the Director of Labor Relations, John Berard. And his testimony is important to understanding the bargaining that went into that 2012 telework policy in the first place, and the events that transpired when that policy was first issued. He will also be able to provide context from the labor relations perspective on the COVID pandemic and, of course, some of the interactions between the state and VSEA as the state navigated that COVID pandemic. He'll also provide further details on ESD's 2024 suspension of telework and the interactions with VSEA on that front. Finally, he'll provide testimony on the 2025 return to office, including VSEA's request to bargain and the state's response. He can also provide further details on the hybrid work standard and how it relates back to that 2012 telework policy. And finally, he will shed light on how the discussions for the collective bargaining agreement that goes into effect later this year connect with that hybrid work standard. We look forward to presenting the state's evidence in this case, and we appreciate your attention to this matter. Thank you.
Thank you. Does the union have a witness?
Yes, we do. I would just query council as to whether we want to start with Mr. Howard today and take the risk that Mr. Brown may not finish by the end of the day. That was a concern previously.
Our concern with that would be Mr. Brown won't be available on Monday if we should run over, run into that barrier. So we would recommend that Mr. Brown testify first so we don't have that concern.
And we agree that that's the best practice. I'm happy to take him out of work.
All right. There being no objection, we'll take Mr. Brown as a witness.
Thank you.
Morning, Mr. Brown. I have an oath for you. Do you solemnly swear or affirm under pains or penalty of perjury that the testimony you shall give relative to the cause now under consideration shall be the truth, the whole truth, and nothing but the truth?
Yes.
Welcome. If you could arrange an introduction for Mr. Brown by position and title, etc., that would be helpful.
Of course. Mr. Brown, could you please introduce yourself to the board?
Yes, my name is Sean Brown. I'm the Deputy Secretary of the Agency of Administration, and I do want to thank the board and VSEA and VSEA's council for accommodating my schedule, so I'll be able to travel next week on vacation. So I truly appreciate the opportunity to be here today.
And I just want to thank you, but I also want to ask you if you could please speak up just a little bit. That'd be great. Thank you.
And can you tell us a little bit about your current position?
Yes, I was appointed Deputy Secretary in December of 2024. So the Agency of Administration day-to-day oversees and supports the Departments of Human Resources, Buildings and General Services, the Tax Department, the Department of Libraries, and the Department of Finance and Management, and also several other smaller offices, Office of Racial Equity, and also the Chief Performance Office as well, and Risk Management, and a Financial Services Division that supports all of the departments within the agency financially. Also, we support the Governor's Office day to day as well, and develop the budget, proposed budget, the Budget Adjustment Act, and also policy initiatives. So we're very involved in the day-to-day operations of state government.
And before you became Deputy Secretary, what was your role in the state?
Yes, I was the Chief Operating Officer within the Agency of Administration. I moved over to the Agency of Administration in the fall of 2022. And I served in that role as Chief Operating Officer for the state and the Agency of Administration for just over 2 years.
And before you were with the Agency of Administration, did you have additional roles with the state?
Yes, before moving over to the Agency of Administration, I spent the bulk of my state career in the Agency of Human Services from approximately May or June of 2020 to when I moved over to the Agency of Administration. I was a commissioner for the Department for Children and Families. And prior to that, from the spring of 2014 until I was appointed commissioner by the governor, I served as deputy commissioner of the Economic Services Division. And then prior to that, for about 2 years, I served as an operations director in the Economic Services Division. And then prior to that, from 2001 until 2014, I was in the Office of Child Support in various management positions as regional manager. And then when I left there to go over to Economic Services, I was what they now call the deputy director of the Office of Child Support. And then prior to that, I worked in the legal unit of the Department of Mental Health. I'd come from private sector, but before that, I had worked for this in 1997. I started working with the Department of Mental Health in the legal unit. I was in the private sector for a couple of years, but initially started with the state in September of 1991, worked in the judiciary until the spring of 1994, when I had that couple of years in the private sector before I returned to the state.
Thank you. And I believe you talked about your current responsibilities a little bit, but can you describe your current responsibilities as they relate to the telework and the hybrid work standard situation?
Yeah, so the Department of Human Resources, which oversees and supports the state workforce, is within the Agency of Administration. And so we're very attuned to what's happening. As a result of that, we meet regularly with the commissioner and the deputy commissioner, the field managers, the labor relations, to get a sense of what's happening, in terms of the state workforce. But we also, being connected to the governor's office, we're also connected to their constituent services. And we also, Secretary of Administration is like the pinnacle of state government. All of the other appointing authorities report up through that structure, and then to the governor's office. And so we actually support a lot of the rest of the state government as well, meet regularly with the leadership of the Agency of Human Services, the secretary, the deputy secretary, We meet regularly to understand what's happening in the Agency of Natural Resources, Agency of Agriculture, Agency of Digital Services. So we're like the hub of where everything flows up through for state government. So we're very involved in day to day of what's happening. Whether it's something that happens in public safety or the Agency of Transportation, it usually flows up through us and then to the governor's office if it needs to get escalated to that point.
Thank you. I'd like to, if you could turn in that line to Exhibit F.
Once again, just a reminder that we all need to speak up, both for the recording and for people watching remotely. Thank you.
Thank you. So I'd like you to talk a little bit about your experience in 2012 and your knowledge of the state's telework policy when it came into effect.
Absolutely. And I will try to speak up. I unexpectedly had to have some oral surgery in January, so I have something in that makes speaking a little difficult, but I will do my best.
Thank you.
Yes. You know, to have to step back in time a little bit from the February 3rd, 2012 memo from Secretary Spalding with the telework policy that was established and through bargaining with VSEA. You know, in 2011, I was at the Office of Child Support working in the Waterbury State Complex when Tropical Storm Irene came through and inundated the complex and made it, you know, we couldn't use it. It needed to be replaced. And so we quickly, were without a home. Many of us were without our computer equipment. And, you know, we were waiting to understand what was going to happen. It displaced, well over 1,000 of state employees, much of the Agency of Human Resources. And so that happened, I believe, in August of 2011. The state at that point was scrambling to find office space for well over 1,000 employees across, and where a portion of the Agency of Human Services relocated to was a big vacant manufacturing building at IBM in Essex, Vermont. And that was very disruptive for a lot of employees at the time, including myself. I'll just say, for me, it doubled my commute, my miles and times, because I live east of Montpelier by about 30 minutes. And so having to travel to Essex was a big change at that time. And we were trying to manage and support staff at that time who were impacted by that change. And so there was a lot of conversation. We didn't have any guidance on that. We really didn't have the technology at that time in place because it really wasn't utilized for teleworking. And so, managers were kind of sending up through, like, we need guidance. We need support here to help us kind of figure out how to support staff. It's because we recognize some staff had the ability to telework and others didn't, and we wanted to try to have some guidance on that in a policy. And so we're sending that up through our appointing authorities to the Department of Human Resources. And I think at that point they reached out to VSEA and a policy was bargained. And then we slowly began implementing that policy in 2012. And at that point, I think as it's been mentioned early on, it wasn't utilized a lot. We felt like for staff that deliver direct service, it was important that they be in the office and meeting with clients and providing that support. And also we felt it was important to the teamwork and collaboration to have people together as much as possible, but also wanting to support staff. So we did have a small number of staff that we supported, and I think many of them were probably those that were directly impacted by the flood, would be my estimation based on my knowledge of the situation back then. And so for me, that's, from my perspective, how this policy really came to be was, it was is kind of ironic in a way that, a disaster in a way, led to the creation of this policy, and then the expansion of the use of this policy was facilitated by, another, I wouldn't call disaster, but a worldwide pandemic.
And I'd like to speak a little bit more about, I think you mentioned that the policy, when it was first used, it was used by some employees, not all.
Mhm.
How did employees, how much telework would employees generally work when they made use of this policy?
It was a day or two a week is my recollection.
And how long would you say it continued to be used in that way?
We were dislocated from Waterbury for almost 5 years before we moved the complex. The federal funding with FEMA was resolved, and they tore down some of the complex and then restored and then rebuilt new buildings. So it took about 5 years for that process. And so I would say for that time period, that's the way it kind of went. Like, that's particularly for the staff that were impacted by the flood. And then when we moved back, I would say people, I think, were glad to be back in Waterbury into their main offices. And I would say we continued in that way up till the pandemic, that it was very limited use at that point.
And I do want to get into the pandemic, but before we do, I'd like to talk about some of the specifics of this policy while we're talking about the inception of the policy. And this policy refers to telework. Can you tell me what types of telework that it encompasses? Does it encompass all telework, or is it we're limited to that?
I would say it encompasses telework in terms of like not physically working in the office. Like if you're not physically at your assigned work location, either you're in the field, which I think we consider being in the office, because we have many positions where being in the field is a part of their day-to-day job responsibilities. So telework's really when you're not working in the office or in the field, but working at, for many, it's working at home.
And under this policy, who was responsible for determining if an employee would be approved to telework?
It would be, the agency and department that they were working for, in terms of the, at that point, they would make a determination if the position could be done remotely effectively. And then also, there were broader conversations about, when it was new for us back then. And so we were apprehensive about it because, I'll be honest with you, I came from the world where you were in the office 5 days a week, and we were human services as direct service. And so that was the framework that, you worked in. And so we just wanted to ensure that we were still serving the public, meeting our expectations in terms of responsibilities and delivering benefits and services, particularly in the human services. There's, timeliness is really important in terms of processing someone's application for benefits or services, and also making sure they're receiving what they're entitled to receive in terms of accuracy or quality of work, I would say, we were very worried about as well. And so that's the lens that we were operating in when it was new, and then also the technology back then was not as, I would say, comprehensive as we have now. I would say the technology has advanced and allowed higher levels of IT security, which are always an ongoing concern of just making sure our systems are secure. And I think that has developed over time as well.
And I'd like you to take a look specifically at Bates number 15, which is part of that same exhibit.
Which page?
The upper right-hand corner, you'll see exhibit F,
Mhm.
Bates number 0015.
Mhm.
And on that page, you'll see the section of the policy that deals with termination of telework.
Mhm.
Can you tell me a little bit about how the state handled the situation when telework, for whatever reason, needed to be terminated for an employee?
I'm going to object to the question on the basis of foundation. The question talked about how the state responded in that sort of situation. I think at the time the policy was implemented, the witness was not in the agency of administration, but rather was in DCF. We would be unclear whether he's testifying as to his experience in DCF or whether he's testifying as to something statewide.
I can rephrase.
Thank you. I appreciate it.
Can you tell me about your understanding of how the authority of who had authority to terminate telework or employees?
Well, based on the policy, an employee always had the option to return to the office full time if they so choose and to stop working. And this policy acknowledges that. But also, it was very clearly understood that the appointing authority and management had the authority to terminate based on if there were issues and it was no longer meeting the business needs, or if there were other concerns, regarding someone's telework.
We would object to the second half of that answer where the witness testified that it was plainly understood. He didn't identify who was understood by. He can speak for himself, certainly, but to suggest that there was some understanding beyond himself required from the foundation.
Could Mr. Brown clarify the point raised by the union?
Absolutely. When you said it was plainly understood, what's your basis for saying that?
After this policy was bargained for and was issued, managers received information, through meetings about the policy, what the policy was, and how to implement and use the policy. So I'm speaking based on my knowledge from those meetings back when this first came out, when I was a manager.
And I believe you referred to the management and the appointing authority, who all would be encompassed within the scope of management.
Well, management, there's different levels. There's supervisors, which are mostly in the bargaining unit. And then there's managerial employees who are not in the bargaining unit. And then there are appointing authorities like deputy commissioners, deputy secretaries, and then those all flow up through the agency of administration, where the secretary of administration is at the top of that pyramid in terms of authority. And so when I refer to management and appointing authorities, I'm referring to that structure totality.
And would the governor, how would the governor fit into that structure?
Well, the governor, is elected to be the CEO of the state, to as the chief executive officer for the state of Vermont. And so, the appointing authorities are answerable to him. They're appointed by him and serve at the pleasure of the governor. And so when there are directives that come down, they come down through the secretary of administration and then filter down through the other appointing authorities, down to the secretaries, commissioners, and deputy secretaries of the various agencies and departments.
And when an employee wished to use this telework policy to telework, would they have any paperwork that they needed to complete?
Yes, there's a telework form that to fill out that then is reviewed and signed off by the employee and su- supervisors and managers are the appointing authority for that agency or department, depending on who that was.
And I think I already saw you referring to it, but it's on base number 0016. It's that telework form that we're referring to.
Yes. Mhm.
And does that telework form include any notification to the employee regarding the termination, the possibility of termination of telework?
Yes, it does. So there's a
Objection, the document speaks for itself.
I'm sorry,
The document speaks for itself.
But
sustained.
as a supervisor, were employees, was it your impression that employees were on notice that telework could be terminated?
Objection calls for speculation.
Uh, Sustained.
Were employees informed of the terms under which telework could be terminated?
yes.
How are they
Yeah.
informed of that?
Well, when an employee requested to telework, we reviewed the policy, we utilized the forms. As we were working with the employee, we reviewed the form and making sure, one, that they were accurately recording what their request was, going over the form and the expectations of that form. And I can say from my personal experience with employees who were requesting it, making it clear that it was voluntary and at the discretion of the appointing authority, and that it was something that we were tracking just to make sure the business needs were being met, and or if there were other concerns that they would be addressed.
Thank you. So I believe you referenced it earlier, but I'd like to turn now to the COVID pandemic and how that affected the state of telework for state employees. And to get the conversation going, if you could turn to Exhibit I, the binder.
Yes.
And do you recognize that?
Yes, it's executive order number 0120, issued by the governor in 2019 in response to declaring a state of emergency for the state of Vermont.
And what effect did issuing this order have on the state of telework within the state?
At the time, it was a substantial change to what was the current practice of what we were experiencing at the time, where we had a limited number of employees in the state workforce utilizing telework. We essentially went remote overnight, where we, except for those positions like correctional officers, or if you were like at the state hospital, psychiatric hospital, or state troopers, like you were asked to telework if at all possible. And it happened very quickly.
You could next turn to Exhibit J.
Exhibit
J.
J. Okay.
On. And I see that this memo was addressed to appointing authorities. What was the purpose of this memo?
I think that this memo was issued approximately a year into the pandemic. when, or on J in 20, excuse me, I apologize. I misspoke. Um, I think this was to keep the public and state employees safe, and providing guidance on how we were going to work and approach supporting Vermonters with the COVID-19 pandemic that rolled out.
And if you look down towards the bottom of the page, there is a paragraph that talks about, it specifically says, consider telework options for state employees. What is that referring to? Is that referring to the state's telework policy or something new?
Objection leading withdrawn.
I'm sorry, could you just repeat the question? How much?
Yeah. So there is a paragraph that says, consider telework options for state employees. What is that paragraph, number one, referring to?
I think it's referring back to the original policy and just reminding folks that that's a tool in our tool belt, and that it was encouraged to utilize telework unless it was absolutely essential to be in the office.
And next, I would like you to turn to Exhibit K. And do you recognize that document?
Yes, this was a letter that was sent by then president of the VSEA, Dave Bellini.
And based on this correspondence, what was your understanding about VSEA's position in regarding telework at the beginning of the COVID pandemic?
Objection. I think the foundation as to when this witness saw this letter would be appropriate. This was in March of 2020 when he was not in the agency administration.
This sustained, and perhaps you could rephrase, offer foundation.
Absolutely. When did you become aware of this letter from VSEA?
I think shortly after, my memory is shortly after it was sent. It was just, it was circulated amongst the various appointing authorities in state government.
And what was your understanding of VSEA's position regarding telework based on this correspondence?
Further objection. Document speaks for itself.
I'm asking about the witness's understanding of VSEA's position.
Overruled.
Yeah, my understanding is that they were expressing the same fears and concerns that everyone is experiencing about at that point. This was very new and first time anyone had experienced a pandemic, and that in their lives, there was a lot of unknowns, concerns that it could be very harmful, particularly to certain populations, and we want to limit the spread of that as the best we could. And that I would say that VSEA and state government were very aligned in their goals here of what to do in response to the pandemic.
And I would like you to next turn to tab Exhibit N.
And is in November.
November, yes. And do you recognize that document?
Yes, I have seen this before. Yes.
And when did you become aware of this memo?
It would be probably within the weeks following that it was sent.
And what was your understanding of the purpose of this correspondence to VSEA president.
Object foundation.
I can ask an additional question. When you became aware, what were the circumstances where you became aware of this memo?
I believe it was discussed at an AHS leadership meeting. At some point in the immediate following it was sent, is my memory. We were meeting regularly as a leadership team from AHS, all the commissioners and deputy commissioners to trying to plot how are we going to implement and work under the executive order, addressing the needs and fears of our employees as well. In terms of, and then, this was a memo back from the secretary to David Bellini in response to raising his concerns. While most of the employees were remote or were working remotely and teleworking, there were still employees who couldn't, like in correctional facilities or hospitals. But also there was a small number of us who continued working with precautions in the office throughout the pandemic, as I did. A lot of it was leadership. We would, and so we wanted to make sure we were taking precautions. The buildings were being cleaned and taken care of, based on the evidence at that time of what was best to combat the COVID-19 virus.
I think you've alluded to this. Would you say that the states, what would you say was the timeline for the state's response to COVID?
It was very quickly. I mean, we pivoted very quickly to remote work at DCF and ESD particularly. At that time, many of our staff didn't have laptops. Many of our district staff had desktop computers and recognized right away what was happening before things shut down. I went on a scavenger hunt to find every laptop I could locate, even those that had been were being transitioned out of use and were being ready to had their hard drives destroyed. We repurposed so that our staff had the tools to be able to work remotely, because saw that that's what was coming based on what was happening in the world and what conversations that were happening. That state government was probably going to go fully remote to the best of its ability in response to the pandemic.
Given this rapid timeline that the state was operating under, were there any procedural requirements normally applicable to telework that were suspended?
Yes, the governor, in one of his executive orders that was issued shortly after the start of the pandemic, basically, we suspended a lot of rules and processes that existed at the time, and formalizing telework agreements was one of those things that we kind of just moved away from because of the urgency of the situation. Like a lot of our benefit programs require an in-person interview. Those were suspended just because of the fear of spreading COVID-19 face-to-face. And so we were allowed to do some interviews, even though it was in violation of federal rules. We were able to, because the federal government suspended requirements as well, we were able to do some things remotely that we weren't able to do. And conversely, when the state of emergency ended, our waiver for those processes went away, and the federal government reimposed some of their rules as well that required in person. And so we had to shift back at the end of that as well.
And since you alluded to this, let's go ahead and turn to Exhibit S. In particular, Bates number 55. And I believe that you were just speaking of the end of the COVID emergency.
Yes.
Um, what was your understanding of how this memo related to that end of that emergency?
Yeah, this was a memo from then Secretary of Administration Suzanne Young sending out to appointing authorities, elected officials and state employees that, as we moved through the pandemic, we were a state that was very successful in accessing and vaccinating its citizens with the COVID-19 vaccine. And as a result, we were able to ease some of the restrictions that were in place in 2021 and the end of this, of like some of the state of emergency. And we were starting to transition back to normalized operations, and that this is what that memo is talking about. Like we're starting to transition out, where those that can continue to telework should do so through September. But then in September, we're going to go back to normalized operations and telework agreements, and to continue for employees who wish to continue working remotely under the telework policy, who during the pandemic were not required to fill out a telework agreement, and many staff were impacted by this change because prior to the pandemic, only a small number were teleworking, and then a larger number were, and we didn't have telework agreements for those staff.
What would be the purpose of having those staff complete telework agreements at this stage?
Well, one, so we understood who wanted to telework, what days they were asking to telework, so that we could, as we normalized operations and had to start operating back under pre-existing rules in terms of service delivery and in-person meetings, we need to make sure we could meet the business needs of the state, the operating needs.
And you referenced meeting the business needs of the state. Who would make the determination as to whether the request would meet the business needs of the state?
Again, that would start at the level of that agency or department, and then then they would make the determination if that fully aligned with the operating needs of their department or agency.
And next, could you please turn to Exhibit T as
Thank you, and I appreciate Attorney Florian, you're emphasizing the T as in Tom. So whenever the attorneys reference an exhibit, if you can do that, that would be helpful, so that Member Phelps can hear it. That'd be great. Thank you.
Thank you.
Which exhibit did you know?
Sorry.
Which exhibit? I'm sorry.
Exhibit T as in Tom.
T. Okay.
And specifically, page number 57.
Mm-hmm. Yes.
And When would you have become aware of this memo?
Shortly after it was issued,
And who all would have received a copy of this?
all appointing authorities, and employees, it went to everyone, is my memory.
And based on this guidance, what was the status of telework at this point?
At this point, we were transitioning from the pandemic-based waivers that were in place to back to our normalized operations. And this memo was laying out that transition that was going to happen as we normalized back to more work practices. Particularly with respect to telework.
And next, could you turn to Exhibit B as in vegetable?
Yeah. Well done.
Specifically, Bates number 70.
70, 70. Great,
Yes.
thank you.
And could you tell me in general, what was the purpose of this document? Or your understanding of the purpose of this document?
Yeah, this document was issued as we came out of the pandemic, and we're trying to normalize operations and return to our standard operating practices, particularly with respect to telework. That this was guidance that was issued out to help appointing authorities and managers and supervisors as they were supporting staff with this transition.
And you mentioned supervisors and people on the management of employees. Would this document also have been accessible to employees?
Yes, I believe this was posted out on the DHR website, if my memory is correct.
I'm sorry, if I could just ask you, at the end of your sentences, you have a tendency to lower your voice. Thank you.
Apologies.
So the questions that are asked on this form, employees would have been able to access those questions and they.
Yes, yes.
Next, please turn to Exhibit W as in William. And do you recognize that?
Yes, this is a memo from Commissioner Fastigi, Commissioner of the Department of Human Resources, that again went out to all state employees, appointing authorities, and elected officials.
And what was your understanding of the purpose of this memo?
As we normalize telework again coming out of the pandemic, we were coming out of that state of emergency where we were just trying to meet the basic needs of state government, keep people safe. We're starting to normalize here. We wanted to ensure that we were providing proper education and tools to employees, like making sure people were taking the required IT security trainings to ensure our system were safe, that we didn't experience any breaches as a result of telework, and also how to access your accounts remotely, and then also about providing some trainings as we were normalizing out of the pandemic, realizing more employees were teleworking now than they did. We just wanted to provide some training and support to employees where we didn't do that before.
I'd like to shift gears now to talking a little bit about events as the state shifted into 2023 and 2024. Were there events that affected the state's ability to normalize operations during that time frame?
Yes. On July 10th, 2023, Vermont experienced a significant rain event. And it significantly impacted many areas of the state. But one area that was impacted in particularly hard was Montpelier, which is where many of our state buildings and offices are located. And once again, I was impacted by the flood, and many of the state buildings were uninhabitable for a period of time. And we needed to relocate staff, and again, telework was utilized for staff who had been working in the office more regularly at that time. And then we also staff that needed to continue to work in a safe space, like processing checks or whatnot, or tax returns have to be done securely. And so we needed to ensure quickly that we had locations for those staff to we were quickly moved to space that was created for us. Governor's office, the 5th floor, I would say. We moved up to the Agency of Transportation building up across from the airport and worked there remotely, not remotely, but worked there in person until February of 2024, when we were able to go back into our building after the water damage was pumped out. The water was pumped out. The building was dried out, and that systems were restored, and our elevators were restored as well. We were one of the last buildings, I think, to open back up during that time frame. Others, some were less impacted, like 120 State Street had been flood proofed during renovation earlier, and fortunately, those renovations worked. Absent a sump pump failing where we had some water in the basement, but they were quickly able to, before it damaged too much. And so like that building was able to be reoccupied much earlier than some of the others where unfortunately like the elevators were programmed to drop when the power went out during the flooding. And so they were ruined as a result of that. And so they need to be replaced. So we couldn't reoccupy until everyone could reoccupy.
And I think you alluded to this, but how extensively were state operations impacted?
And if I could if you could speak up, because unfortunately we've got horrible acoustics and that doesn't amplify. So
I
we've got to use our choir voice or teacher voice or cheerleader voice, whatever,
Lifeguard.
acting voice.
I'm not used to raising my voice. So.
Okay. Stern parent.
Yes. Operations were significantly impacted. The infrastructure for many of those buildings was underground and went down many layers underground. And so the electrical systems, the heating systems, the ventilation systems were all destroyed in many of those buildings. And first they needed to be just pumped out. There was a significant amount of water in the basements of most of the buildings that the state owned, and then the State House in 120 needed to be pumped out. And then we need to bring in vendors to dry the building, take all the damaged material out, the sheetrock. Some of the damage went up into the first floors of the buildings. So it was significant damage. We're talking hundreds of millions of dollars of damage was done in terms of cost to repair. And some of those repairs are temporarily made, and we are currently working with FEMA to make the permanent repairs to many of those buildings at this point.
I'd like to next turn to specific events that happened in 2024. If you could please turn to exhibit double E as an element. And are you familiar with that community?
Yes,
How did you become familiar with that?
I was familiar with it from my work in the Agency of Administration, just when they were considering bringing staff back. That was something that was came up through their appointing authorities to the Secretary of Administration, and then so that it was discussed on the fifth floor and reviewed and approved, and then they implemented. So I was aware of this happening.
And I believe this document says that, well, let me back up. So what was the purpose of this communication?
The purpose of this communication was to share with employees that based on the operating needs of the department and the division and serving public, that they were suspending telework and bringing district office staff back to work in person in the office full time.
And it uses the term suspended. Did telework at some point resumed for these employees, or did it remain suspended?
At this point, it remains this remains in place for these impacted staff.
And I believe you alluded to this, but just to ask it directly, who made the determination to suspend telework for these affected staff?
Well, it was originally discussed amongst the division and department leadership, and then up through the agency appointing authority, and then up through the Secretary of Administration and in the governor's office, and which was approved and then was implemented.
What was the basis for the authority to suspend telework in this for these employees?
Well, the telework policy clearly outlines that the appointing authorities have discretion based on operating needs. It's not a right. It's and they based on what they were experiencing at economic services with a backlog of work and an error rate that was increasing based on history that happened before under somewhat similar circumstances. They made the determination they needed to bring people back in to the office full time to support the public.
I'd like to next turn to the current return to office initiative, 2025 initiative. Let's start with exhibit number 11.
It's the other book. It's the white book.
In the white binder.
And just for the board's awareness, if the board would like to take a break at this point, this might be a natural break in time.
Objection from non-council.
I would
Okay.
love a break.
Let's reconvene at 10 of 11. That would be 40 minutes. This time we're back.
Yep.
And we are at
I'm sorry, could you just provide that answer again? Because there might have been a period where it was muted. I apologize in terms
okay.
of what the purpose was.
Yeah,
My
this was
apologies.
a memo sent out by the Secretary of Administration following up from the governor's press conference the day before, where he declared we'd be moving to a new hybrid work standard under the existing telework policy. And so this just provided initial confirmation and just assuring staff that there would be a process and more information would be coming, since this was new information to many employees.
And next, I'd like you to turn to exhibit 12, 1, 2.
Yes.
And when did you come to where this came?
From its origin, again, I was involved in helping the drafting of this communication.
What was the purpose of this communication?
Again, in the spirit of making sure we were communicating to the workforce, this was providing updated information about the path forward to the transition, and so provided information. So it sets the standard at 3 days a week in the office with 2 days of telework. It sets a timeline of that the new standard would be on 12/1/25, and that we would be a planning process, and that we would provide updated information throughout the process.
And this refers to a minimum of 3 days in the office.
Mhm.
Does that minimum apply across the board, or could that vary?
It applies to, well, for those employees that are able to telework, the 3 day in the office is the minimum, but there are many employees, as I think has been referenced here earlier, like corrections officers, public safety officers, others who are not able to telework and work in the office 5 days a week. So, but this as a blanket, this new standard applied to all classified and exempt employees in the executive branch, like including myself.
And we referred in your earlier testimony to some ESD employees, Economic Services Division employees, who had come back to work in person full time in 2024.
Yes.
How were they impacted by this?
Given that theirs was already changed to be full time in the office, this wouldn't have impacted them in the short term. But once, if an operational decision is made by ESD and DCF leadership that they want to consider easing the 5 day a week standard for those ESD employees that were impacted, that they would then be subject to this policy of a minimum of 3 days a week in the office.
So under this hybrid work standard, how does that connect with the existing telework policy?
The telework policy provides the framework for this approach. Like, that's the policy we're operating under that was bargained, where it was within appointing authorities discretion based on the operating needs of what telework would be allowed or not allowed. Here, the governor, the ultimate appointing authority, came to the determination that a 5 day a week in the office, but allowing up to 2 days of telework under the policy was the new standard. And so that was the framework we were working on.
And if you could please turn to exhibit XX, as in xylophone.
Back to the other binder.
You said XX.
XX.
Okay. There it is.
we had previously looked at the telework form that was attached to the policy.
Mhm.
Were there any changes to how the telework form was processed in connection with this new initiative?
Yes, well, one, it was a paper form before, it was a paper-based system. We created an online form for employees to use and for the escalation and approval process.
And why was an online form created?
Prior to this new standard, as I indicated, it was a paper-based system, and there was not a central repository where every telework agreement was retained. Here, this centralized it and allowed us to better track and follow the request, be aware of all the different who had a request and what was their schedule.
We've talked about the telework policy and how it plays into this hybrid work standard. Are there other policies that come into play as well?
Yes, one, we also, as a part of this process, recognized that there would be employees who had circumstances where they might be impacted and might not be able to comply with the new work standard due to no fault of their own. And we wanted to create a process where they could request an exception to the new work standard based on their circumstances. The guidance used the word compelling circumstances and listed some examples of what that might be, but that was not limited to those or an exhaustive list. Also, we have the reasonable accommodation process where if someone has a disability or medical condition, that will not allow them to come into under the new work standard, that they could request a reasonable accommodation from that. So that process exists as well. Also, there is a process under the existing contract, request an alternate work schedule, to flex your hours depending on your unique needs. And so there are many different tools available to support staff under this new standard.
And you alluded to the exceptions process.
Mhm.
Can you tell me a little bit more about how the exceptions process works?
Yes, so we created a process. And again, it's an online form, but you can also do it verbally, or you can do it with another type of form as well. There's not one single way. I've seen them come in different ways. If it is verbal, we do document it just so that we have a record of it, and also can document the decision on that request as well. And so it starts with a conversation between the employee and their supervisor. And then if there's, we document it, and then moves up through the appointing authority for that individual department or agency. And then from there, it goes up through to a committee made up of HR professionals, our chief recovery officer, who's played a role, which was created after the flood of 23. A chief recovery officer was created, and they're playing a role here. And he was unofficially in that role prior to that, because he played a similar role in the pandemic in terms of coordinating our work with FEMA and funding and the other federal funds that came in through the pandemic, where the state received significant amounts of federal funds that needed to be managed and tracked. And so the chief recovery officer, while not known as that then, played a similar role. And then after the first flood and then the second flood of 24, has played a more central role in responding to the floods and working with FEMA and just in that as well. As chairs that process, and they review the recommendation and then send it up to the Secretary of Administration, who's the ultimate decision maker for those exceptions.
In that committee you described, would that be known as the exception review team?
Yes, yes.
And just, could you just list the titles of the folk on the exception review team? Just make sure that we have all of them. That'd be great.
There's Doug Farnham. I don't know, I can't immediately recall all of the names, but there are a couple appointing authorities, I think, from in state government. There are a few HR professionals from DHR on that team as well.
Does anyone know
And I
who's
can,
on?
I can get you a list of those names. Absolutely.
And Doug Farnham, his title?
He's the Chief
He's
Recovery
the recovery
Officer.
Okay, thank you.
Mhm.
What is the purpose of having that team? Why is there an exceptions review team?
One, to make sure we're being consistent across the enterprise in terms of how we're viewing and treating employees. I think it's very important that employees with very similar situations get the same outcome, and so that we're not being inconsistent.
Are you familiar with the current status of exceptions?
Yes, my understanding is as of just recently, we'd received just over 600 exception requests, like just under 610 is my understanding. 127 have gone through the full process and been approved by the Secretary of Administration, and the rest are still under review. And those employees who submitted those exception requests are able to continue to work their work schedule that existed prior to the new hybrid work standard. So at this point, all of those employees are still working as they did before 12/1 when the new standard went into place. And at this point, no exception requests have been denied.
And can you tell me what the review process for exception requests entails?
Yeah, just one, understanding what their unique circumstances, understanding what was like. We didn't know of all the permeations that we might see from state employees, and so one is just understanding, and we have updated guidance periodically based on what we're seeing. And we also want to support our employees, who have unique circumstances, like, they might have a spouse in the military who's deployed and they have duties, at home taking care of young children, or they have childcare or other type of, like due to custodial arrangements, domestic violence. Where they have a partner or child who has a serious illness, and they need to be available to, if a crisis happens, respond very quickly. But I've approved one of those, seen that request come up through from our agency. And so we just want to make sure we're understanding the full universe of the circumstances, and so that we can be responsive.
And you alluded to reasonable accommodations requests. Are they handled by this committee, or are they handled?
No, that is handled by an internal committee in the Department of Human Resources, and that pre-existed this. That committee has always existed and operated, and has been in operation since I can remember, because we have staff who have unique needs and need a reasonable accommodation based on either an illness or a disability. And that committee, reviews them after the interactive process between the employee and the HR manager responsible for that division or department where that employee works, and then try to come to a resolution to support that employee. And then it goes to that committee for final review and determination for that request.
So when you describe there being just under 610 requests, would that have included reasonable accommodations requests, or?
No, that's separate.
How has the process for requesting an exception been communicated to employees?
Um, um, Starting from that first communication on August 8th, as we developed and refined our guidance, we tried to issue a communication once a week, usually at the end of the week, updating staff and pointing them to the updated guidance that was posted on the DHR website, so that everyone had as up-to-date information across the state, our employees who were impacted by this, so that they knew what to expect.
What about out-of-state employees? Are they handled? Do they have any separate processes that apply to them?
Yes, the standard impacts them a little differently. The requirement is for that they need to be able to comply with the standard by June 30th, 2020, by the end of June 2026. And they needed to, managers and supervisors are supposed to start the conversation to first educate them about this new part of the work standard, and then conversation about are they looking to relocate back to a commutable distance to an office in Vermont, or are they going to other employment outside of working for the state of Vermont.
And you mentioned communications, sort of ongoing communications and updates. Have there been instances of confusion among managers or supervisors as the state has been implementing the hybrid work standard?
Yes, yeah. Early on, particularly with respect to the exceptions process.
And if we could just clarify, this is in 2025, not back in 2012.
Yeah, this is now. We're talking after the announcement by the governor in August, and us creating these new processes and documentation. As we were rolling out the exception process and educating employees in some limited circumstances that it came to our attention, made a request, and we had in isolated areas a few managers say, we don't think this is going to be granted, so don't submit it, and so they didn't. And when that came to our attention, because a part of our process was we started meeting regular with the human resource field managers who are out working with appointing authorities and managers and supervisors. We started meeting with them regularly to get an update of what's going on in the field. What are you hearing from employees? What are you hearing from managers and supervisors? What are your suggestions of maybe improvements or other communications we need to make? And it was through that process that we first learned of some isolated circumstances. And we reached out. The chief recovery officer took the lead in reaching out to the appointing authorities in those areas to educate them that wasn't following the guidance, and that those employees need to be supported in filing their exception, because they can't prejudge. They can make a recommendation whether they support it or not, but that there's a review process, and that the secretary is the ultimate decision maker, Secretary of Administration, excuse me. And so we reached out and educated our managers and appointing authorities on that, and they were then reached out to the staff to ask them to submit. And I actually personally spoke to an employee who reached out to me after the civil Superior Court hearing and heard my testimony. And that happened to them, and I instructed them they should submit their form as quickly as possible, and that there's a process, and that they are free to work their pre-12-1 schedule throughout that process. And so, and then we and educated that person's leadership team that they weren't following the process and they needed to.
Could you please provide the date of your Superior Court testimony, if you recall?
That was just before Thanksgiving, correct? It was like, I don't remember the specific date, but it was like Wednesday or Tuesday or Wednesday before Thanksgiving.
We can stipulate, right? It
Yeah.
was the day before Thanksgiving,
Thanksgiving,
so whatever
thank you.
that Wednesday was.
Yeah.
And I would note for the record that it's not, well, it's not in the record yet, but a copy of the testimony is in proposed exhibit 42. And we'd be happy to provide the entire transcript of that proceeding if the board needs it.
I just, for purposes of his testimony now, so the board has a context of when that took place. Thank you.
So we talked about employee exception requests. Is there a mechanism in place for the appointing authority or an employee's management to request an exception as well?
You mean, yes, all employees impacted by the new work standard have the ability to request an exception.
Could an employer request an exception on behalf of, say, a group of employees?
Yes.
And how would that work?
That would be the appointing authority for that agency or department would reach out to the Secretary of Administration to start that conversation. Some have come verbally, some have come in writing, like we did because of just needing to upfit new space in Waterbury for some employees in the Agency of Human Services. We gave waivers like for employees until we were assured that space would become available. So some employees, like with, I believe it's the Department of Vermont Health Access and the Department of Health, were exempted just because we were upfitting new lease space for them in Waterbury. Also, there is an ongoing conversation regarding a waiver for the Agency of Education. They're really focused right now on education transformation across the state, and it's important for their staff. They want their staff out in the school districts and out working with education professionals. And so we're working with them for the staff that they need out about who that is and for how long until we can create some new regional space across Vermont for employees who really need to be closer to those they serve than coming to a main office in Waterbury. I think we recognize that there are certain positions, even though they had been office-based, there are initiatives or times when it's really important for them to be close to those they serve. And so the Agency of Education right now, as they're engaged in education transformation and working on trying to move that forward with the legislature and the administration, they felt it was important. And so we're trying to, they have staff who are being allowed to work telework right now as we kind of move that forward for them.
Thank you. That's all the questions I have.
May I inquire?
May.
Thank you. Morning, sir.
Good morning. How are you?
I'm doing well. Thank you for agreeing to testify out of order today. Let's start at the very beginning, because I hear that's a very good place to start. You gave some testimony on direct examination about the original implementation of the telework policy 11.9 back in the 2012 timeframe. Do you recall that testimony?
Yes.
Can you remind us what your position was with the state from the sort of October 2011 through February 2012 timeframe was?
I was working for the Office of Child Support in a position that's now called Deputy Director.
Did you have any direct involvement in the creation of that policy?
Not in the direct bargaining and creation, no.
What role, if any, did you have with the policy in the direct bargaining and creation?
Providing feedback and information our appointing authorities about the need for a policy and some direction.
When you say our appointing authorities, you're talking about those within the
Agency, yeah, Department for Children and Families, and the Agency of Human Services.
You indicated during your testimony on direct that when the policy was finalized and distributed, that there was or were some management meetings about the policy that included commissioners and deputy commissioners. Do you recall that testimony?
Yes.
Did you attend any such meetings?
I don't know if I was in the higher level meetings with what would be then, because I was not an appointed authority, but I was in meetings with managers at that point where it was when it was rolled out and we were educated on the policy.
How many such meetings did you attend where you were educated on such policy?
At least one.
And who do you recall running that meeting?
My memory is it was someone from the central office of the Agency of Human Services.
And the people who were participating in that meeting, were they all from the Department for Children and Families, or were they from across various state agencies?
I'm not, my recollection is not that. I don't recall specifically.
And as you turn your direction to council, please make sure to speak up. Thank you.
At the meeting that you were present at, were there any representatives from the Vermont State Employees Association present?
I don't believe so. And it wouldn't be common for them to attend a meeting like that.
I'm sorry, it would or would
Would
not.
not be common.
And I'm just going to speak to direct your answer
Okay.
to myself or
Okay.
Attorney Florian. So that might
Okay.
project a little bit. Thank you.
I will take no offense. If you're not in any way.
Can you just re-ask that question so I make sure I understood it correctly,
I believe
please?
my last question was whether any representatives from the Vermont State Employees Association were present with you at the meeting where you learned about the policy and its implementation.
And I just want to can I ask a clarifying question? Do you mean
If
like,
you don't
like the
understand,
executive
please go.
director or are you just saying union members?
So I mean representatives, not rank and file union members.
Okay, no, not to my knowledge. Okay,
So, thank you.
Yeah, okay.
So we understand your answer perhaps might mean that there might be some folks in the supervisory unit.
Correct.
We've had this dance once before. Please make sure I finish my question before you answer so that the record is clear.
My apologies.
No worries. All right. So are you familiar with the flexible working arrangements statute?
Yes.
When did you first become aware of that statute, if you recall?
I don't have a specific memory of it. Probably at some point and after it became law, at some point in the near future after it became law.
Do you recall having any management meetings or discussions relating to how, if at all, that statute would impact the existing telework policy?
I don't recall any specific meetings specific to just that narrow a focus. But there's always conversations happening about the telework policy, about alternate work schedules, reasonable accommodation over the years. Just given, the flooding and then the other flooding and the pandemic, there's been a lot of disruption in the last decade or so regarding state operations. And so we utilize, those bargain tools that are in the bargaining agreement and laid out in agreement or established processes like the reasonable accommodation under the ADA. We talk about those regularly and how to use those tools to support staff.
So my question was
If
somewhat,
I can interrupt you,
Sure.
ADA,
Americans with Disability Act.
thank you.
my question was somewhat narrower, sir. I'm curious, I'll ask it somewhat differently. At any time prior to the current return to commute procedures started being discussed, which would be in and after August of 2025. So at any time prior to August of 2025, do you recall having any specific conversations about the flexible working arrangement statute as it relates to the telework policy?
I don't recall any specific conversation.
So I'd like to begin by asking you in general about the policy itself. And I think you've answered some of these questions on direct, but let's make sure we're clear. Under the original policy as passed and negotiated in 2012, the decision-making with regard to whether an employee is going to be allowed to telecommute was made initially by the supervisor with approval of the appointing authority. Is that correct?
Correct.
Objection, the document speaks for itself. Policy.
A cross-examination, I'm testing the witness's knowledge as to the extent of the policy and how it operated.
Overruled.
Under the original telework policy, there was no restriction on the number of days that an employee could seek to telework. Isn't that true?
There was a restriction to the extent that the operating of the needs of state government were paramount. And so that telework days could be limited based on the operating needs and supporting Vermonters.
And if there were no such inconsistencies with business operations, an employee could be permitted to telework 5 days under the original policy. Isn't that true?
That is true.
And indeed, there were quite a few employees who teleworked certainly more than 2 days under that policy. Isn't that right?
I'm aware of the employees who might have been in my sphere that may have done that, but I can't testify as to the rest of the state government because I don't have personal knowledge to every employee's telework schedule.
In preparation for your testimony, did you review the presentation that Commissioner Fastigi gave to the House Committee on Corrections and Institutions on May 4th, 2023?
Yeah, I'm aware of that presentation. Yes.
Have you seen the recording of the live testimony?
I have not seen the recording of the live testimony.
Have you seen Commissioner Fastigi's slide deck that she used in the testimony?
It's been a while, but yes.
I draw your attention then to Exhibit Z as in zebra. Are you looking at that now, sir?
Yes.
And does this appear to you to be an accurate copy of the slide deck that you had previously seen?
Yes.
And remind us who Beth Fastigi is,
She is the Commissioner of the Department of Human Resources.
and she was so on May 4th, 2023.
Yes.
If you could turn with me to case number 0081, which is page 5 of the document. Do you see that page with the words current status in the upper left?
Mhm.
With a yes?
Yes. My apologies.
So the second bullet point under the word current status, I'll read it aloud. Let me know if I've read it correctly. It says schedules range from a few hours per week to full time. Did I read that correctly?
Yes.
So Commissioner Fastigi was noting to the House committee that some employees were actually time, correct?
Correct.
The next bullet says average telework 28 hours per week. And in parentheses, it says 3.5 days per week. Did I read that correctly?
Yes.
And so Commissioner Fastigi was reporting to the House committee that the average teleworking employee was working 3.5 days per week or more. Do I have that right?
Yes.
And there is, to the right of this text, there is a chart showing various percentages of the number of percent of people who are on telework who are working certain numbers of hours. Do you see that?
I see the chart. Yes.
Okay, and so do you see where it shows that 31% of the teleworking employees were working greater than 32 hours?
I believe so.
Oh, you have a black and white
Yes.
version of that, don't you?
Yeah.
Okay, let me see if I can help with that. With permission of your counsel, I'm going to put this in front of the witness so we can see the color version. And grab that.
Thank you.
Sure.
And it, just because the board members have black and white in front of them, they have access to a color. If you can describe, it's the first block, the second block from the top, third block from the top, fourth block from the top, or
Sure.
that'd be helpful.
And I will note that the electronic versions that were
Is
sent
in
across
color.
is in color.
Yep.
First of all, you're not colorblind, are you?
No.
Okay, great. So the top block, what color does it appear to you?
Red.
And what is the percent number in that red block?
31%, I believe.
And you see where that reflects the percentage of teleworkers who are working greater than 32 hours. Do I have that right?
Yes. According to the key. Yes.
What is the color of the block underneath that?
It's a darker blue.
And what is the percent number in that block?
19%.
And what does that relate to in the key to the right?
Greater than 24 hours, less than or equal to 32 hours.
The next block down, what color is that?
The lighter blue,
And what's the number in that box?
32%.
And what does that refer to in the key to the right?
Greater than 16, less than or equal to 24 hours.
So all of those people in that red, dark blue, and light blue box, all of the people reflected in those boxes were working more than, were telecommuting more than the 2 days a week under the new standards. Isn't that right?
Yes. Just doing the math.
Well, the rudimentary math being my strong suit, 31 plus 19 plus 32 equals 82%. Fair? Math
Yeah.
speaks for itself. I'll withdraw the question. Let's presume that my math is accurate. Then 82% of the 3,100 approved telework agreements were for people telecommuting 3 or more days per, or more than 2 days per week. Is that right?
Correct.
Okay. So I will take my laptop back. Thank you. A few more questions about this particular slide, if you know the answers. So the 3,100 submitted approved telework agreements. My first question is, do you know that Do you know about that time in the middle of May of 2023, what the size of the executive department workforce was in total? A range would be acceptable.
A range, just trying to back out like the judiciary and the executive branch, because there's like close to 9,000 employees. So maybe 7,500.
And of that approximately 7,500 executive branch employees, I think we've identified that a fairly sizable portion would be unable to telecommute because they require interaction in a physical workspace.
Right.
So for example, all the corrections officers would be included in that 7,500 number, but unable to telecommute. Correct?
Correct.
The same would be true of people who work with patients in the hospital setting, correct?
Correct.
The same would be true of buildings and grounds crews who have to maintain buildings and grounds.
Correct.
This may be beyond your ken, but I'll try. Do you have a sense as to the number of employees who fall into that category who would be literally unable to telecommute because of the functions of their job?
I don't have that specific number.
Let's take a large chunk. Do you happen to know the approximate number of corrections officers in the state of Vermont?
I don't know specifically corrections officers. I know the Department of Corrections is one of the bigger departments in state government, has over 1,000 employees, but that would be leadership, probation and parole, local offices, and in the facility. So I'm not as familiar with their breakout of their employees.
All right. Okay. Let's turn our attention to the changes that were made to the ESD telework in the fall of 2024. Remind us again where you were employed in October 2024,
I was in the Agency of Administration.
and what was your position in the Agency of Administration at that point?
I was officially the Chief Operating Officer, but I believe at that point, the deputy position was vacant. And I was kind of wearing multiple hats at that point until I was appointed Deputy Secretary in December.
Were you directly involved in the decision to make the change to the telecommuting protocols for those employees?
I was consulted.
By whom were you consulted?
My memory is there was a conversation with the.
Please speak up. I'm sorry.
My memory is it was a conversation with the Secretary of Administration. She was looking for just information from me to confirm their understanding of, based on my work in ESD historically as an operations director and then deputy commissioner. I was very involved for a lengthy period in the operations that were looking to be changed at that point.
When your input was sought, well, first of all, who was the secretary at that point?
Sarah Clark.
And when your input was sought, was that a direct interaction between the two of you, or were there others involved in that conversation?
It was probably just a conversation between the secretary and myself.
You indicated in your testimony that the changes to ESD and the discussions around them may have gone as high as the governor's office. But you had no contact with the governor's office yourself, did you?
That would have been the secretary who would have had conversations with the governor's office on something like that.
And you were not involved in that conversation? during that period of time, were you made aware of the managerial concerns from ESD leadership that led to the change in telecommuting protocols?
You repeat that?
Yes. At that period of time, were you made aware of the concerns that had been raised by ESD leadership that led to the change in telecommuting protocols?
Yes, I was aware because I had experienced something similar when I was deputy commissioner as well.
Did you see any of the documentation that the ESD leadership had received and reviewed in making this determination?
My memory is that I had seen data regarding their timeliness of processing work, requests for services, and also regarding their error rate with respect to the 3 Squares Vermont program.
Please turn to the exhibit marked for identification as VSEA exhibit 10. And I will note that exhibit 10 has sub exhibits 10A through L.
Okay.
We don't have.
Yeah, eighth.
No, you do.
So it's 10 and what letter?
So I'm going to start with 10A. So after the tab for number 10, you'll see A through L.
Got it.
So, Mr. Brown, looking first at exhibit 10A, simple question, do you recognize that document?
I do not recognize this document.
Then I'll move to exhibit 10B, which is a lengthy document that contains a number of emails, handwritten notes, and other printed material. I'll ask you just to to look through those pages, and after having done so, let us know if you recognize this packet of information.
I do not have a specific memory of each document. I'm aware of this package though.
And again, how did you become aware of that package of material?
Just in terms of that they were responding and providing information to the VSEA request.
And though you don't specifically recall each page that we're looking at, do you recall seeing this packet previously?
Probably in passing on some place. When I was referring to data, like these are the symptoms of the data I was speaking of, where historically application processing times are tracked and the error rate, which is reported to the federal government, is tracked. These type of requests coming in are symptomatic of the data I was seeing based on my experience as deputy commissioner, where when you don't process and get notices out to people in a timely way, or you make mistakes on their case, you see an increase in complaints coming in. And this is historically what I experienced and saw when I was at ESD. And the error rate when I took over as deputy was almost 10%, and processing times were significantly past the 30 days. And these were commonplace back then as well. these type of complaints.
Thank you. I'll ask you to turn to exhibit 10H, please. H is an arrow.
10H. Hold on.
I'm going to hand you a copy of
That would be
exhibit
great, because
10H.
not every page is labeled, so thank you.
Sure. Do you recognize that document?
Yes, I believe I've seen this before.
And you saw this during the time period when consideration was being made to change the ESD commuting protocols, correct?
And I may have seen similar data before that, just because this was a growing concern and just an area that, as the agency administration, these things filter up to us. And so we always try to keep our finger on the pulse of what's happening. And I just always had a connection to ESD and would regularly communicate with the deputy commissioner, former colleagues.
The unit would offer exhibit 10H.
They would have checked in terms of relevance. This deals with the 2024 return to office for ESD and not the current.
I believe the state made an issue of the ESD, suggesting that the union waived some sort of right to bargain because of what happened with ESD in 2024. The union is submitting to you information provided to the union that explains the state's rationales as being related to the inconsistency with business operations.
The objection's overruled and we'll admit the exhibit.
Thank you. So getting back to the root of the ESD situation in 2024, I believe you testified that you were aware that there was data supporting a concern about the telework being consistent with business operations, right?
Mhm.
That's a yes?
Yes,
And the original determination to suspend telework came from the deputy commissioner to the commissioner of DCF, correct?
that's my understanding.
And it related to a individual subgroup of employees who perform similar job functions, correct?
Yes.
All right. If you would now turn with me to tab 11, that's Union Exhibit 11. And we should be looking at an August 8th, 2025 memo from Secretary Clark to all state employees. Is that right?
Correct.
I believe you testified that you had a role in the drafting of this document. Is that right?
Yes.
What role did you play?
Just as the secretary was drafting this, she asked for input from her team, which I'm a part of. And so we all provided, support in drafting it and then editing it to its final format.
Okay, at this time, August 8th, 2025, the administration had yet to make a determination as to what the underlying parameters would be. Is that right?
Correct.
The prior day in his press conference, did you see the press conference?
I think I had it streaming on my computer while I was working.
Do you recall what the governor said about how many days per week employees would be required to return to commuting?
I don't recall. I just remember he was responding to a specific question from a reporter.
Do you remember him any parameters that he suggested as to how many days per week he thought
I don't recall specifically from the press conference.
It's fair to say, though, that as of August 8th, the administration had not yet made the determination about the 3 days per week in office requirement, correct?
Correct.
So looking further at this same message and looking at the fourth paragraph, which says the process will involve input from a focus group of state employees from multiple agencies. Do you see that?
Yep.
Is there was there a team of state employees working project on and after August 8th?
My recollection is that a team was put together that was led by the Chief Recovery Officer, Doug Farnham.
And were you on that team?
I was not on that team.
Okay. The last sentence of this document, I believe says, or excuse me, the last paragraph starts with, this process will take us time and we will provide more information as the strategy is established. Did I read that correctly?
You did.
So as of this point, the state had not identified the strategy that it was utilizing. Is that fair?
Correct.
As relates to the team of people who are working on this project, are you aware whether the VSEA asked to be included on that team?
I'm not familiar with that.
Are you aware whether any representatives of VSEA actually were on that team?
Not to my knowledge.
Let's move on to Exhibit 12, please. We should be looking at an August 28th memo from Secretary Clark to all state employees. Is that what you're seeing?
Yes.
Did you have a role in the review or drafting of this document?
Yes.
So I can perhaps skip this, asking you this question 15 times. At some point, Secretary Clark began a weekly memo to state employees, correct?
Correct.
Did you have a hand in reviewing or putting input on the entire stream of messages?
My knowledge, yes.
Thank you. So back to Exhibit 12 then. The first paragraph, Secretary Clark suggests that we, in quotes, have been working on a plan for the hybrid work standard. Again, was that the team that you referred to who was working on that?
That included that we was a very broad we. It was that team. It was working with our HR professionals at the Department of Human Resources. It was with the governor's office and his staff. It was with the staff from the Agency of Administration. Also, there was conversations happening by the secretary with other appointed authorities to get the, because there was a lot of questions coming in from leadership from across the state. And so a lot of information was being gathered at that point. So when I think the we, it's this bigger we.
Perhaps I can help. Look at the bottom of that first page. Under the subheading remote and in-person standard, the secretary talks about input from AOA as well as VGS, Human Resources, State Recovery Office. Those, your knowledge, those groups were all involved in helping set this standard, correct?
They were involved in aspects of it, whether they were involved in every decision.
Let me ask you specifically about the Department of Buildings and General Services. At this point, who was in charge of that department?
Wanda Manoli was the commissioner, and Emily Kasicki was the deputy commissioner.
And VGS would necessarily have to be involved because whatever happened here was going to lead to a number of employees returning to in-person work who were not at that time working in person, correct?
Correct.
And some employees who might have been working in person only 1 or 2 days per week might now be working in a location where everybody is working in person at least 3 days a week. That's the standard, right? 3 days per week?
Yes.
So, fair to say that at the moment in time that this message came out, Buildings and Grounds did not yet have a plan for where everyone was gonna work.
Well, for many agencies and departments, the space that was available to them was suitable for their employees to come back under this work standard. There were other agencies and departments which had grown, or for instance, in Burlington, where the health department was located, we were in the process of selling 108 Cherry Street, which was a state office building, and we knew at some point we were going to need office space for those employees, and so they were involved in that process as well.
In fact, sir, isn't it true that the state over the period of time since COVID to August of 2025 had let go of a number of either leased or owned office spaces that employees used to work in person?
I can't speak to many. I know 108 was decided to be not used as a state facility and sold because of the condition of the building and the cost that it was going to be to renovate and fix that. The structure of that building far outweighed its investment, and so a decision was made to seek legislative approval to sell that building, which we received.
Let me ask something somewhat different. As we sit here today, more than 2 months after the hybrid standard went into effect, there are currently employees who cannot return to in-person work because there is no space for them. Isn't that true?
We are in the final stages of, and that's one of those in direct exam when I was questioned about, whether we granted more broader waivers for groups of employees. That was a group that we did because we needed to lease new office space in Waterbury, where it's been a long-term goal to transition the health department staff to Waterbury so that all of the AHS departments, central offices and core offices were there. I mean, that was a conversation that happened when I was a deputy commissioner and a commissioner at DCF, that was talked about as a long-range goal to bring the Department of Health down to Waterbury. And so this new work standard, we are leasing additional space to bring back DEVA, Department of Vermont Health Access, who process healthcare eligibility, as well as Department of Health staff.
Are those the only two groups of employees for whom you've had to lease additional space, or has other space had to be acquired between August and now in order to accommodate the hybrid standard?
I don't believe we have leased additional space, but I would want to verify with our commissioner of VGS to be sure.
I would presume that leasing additional space comes at a cost to the state, right?
Yes.
Sorry, could I just ask for a clarifying question? The question was, are there currently employees who cannot return to work because there is no space for them? Is that a yes or no?
We've entered into, and I can't answer the specifics.
As of today.
And that's what I need to verify, because they were due to move in February. I just don't remember the exact date. And so they might be in the space now. And so if so, it would be a no to the question. If it's in 2 weeks, the move-in date, it would be a yes. So I just need to know the exact date.
So at least as of February 1, the answer would have been yes. As of February 1, there are currently employees who cannot return to work because there's no space available for them.
Correct.
Thank you.
All right, so looking at the bottom of page 1, still in Exhibit 12, and onto the top of page 2, we see the hybrid work standard of a minimum of 3 days in the office and the timeline effective December 1st, 2025. Do you see that?
Yes.
And this is actually the very first time that standard and that date was announced, correct?
Correct.
Do you know how the December 1st date was chosen?
there were a lot of conversations occurring about the timeline to implement the new hybrid work standard announced by the governor. And whether it should, we wanted to put it far enough out so it gives time for a process, and also for staff to adjust and be prepared for this change, but also understanding the importance of this and implementing it. And we fell on December. We wanted to make sure it was before January, because in January things get very, very busy, where we are finalizing the governor's budget, we are finalizing the Budget Adjustment Act, the capital bill, and other significant pieces of legislation in anticipation of the legislature coming in the first week in January. And so we didn't want to make this transition during the legislative session. We thought it would, we wanted to do it beforehand. So we settled on December 1st.
I heard you use the word "we wanted" several times in that answer. There was nothing happening that required this change to be on or before December 1st, was there?
There was no specific thing driving to that date other than weighing all of the considerations that we were discussing. We felt that December 1st date gave staff from the end of August through the fall, and several months to adjust or seek through this process we created, the exception process or the reasonable accommodation. So those staff that had concerns not be able to meet the new standard had an opportunity to submit those requests and continue to work their old schedule. We felt December allowed that process to happen, but also allowed us to implement this and normalize before the legislative session began.
As of August 28th, 2025, the state had not yet implemented the exceptions process, had you?
No, but we knew we were going to create a process to support staff.
I'd ask you to turn with me to Exhibit 23, please.
23.
23. Exhibit 23 is the October 14th, 2025 memorandum from Secretary Clark to the workforce. Is that right?
Yes.
And this day, October 14th, 2025, more than 2 months after the original announcement, this is the first time the exceptions detail was announced. Isn't that right?
I believe so.
So you started by giving employees 96 days from August 28th to December 1st. And now we're at, let's see, about 48 days to get through the exception process. That's where we were then, right?
I will trust your math.
The math is mathing. Yes. So while you may have had a plan in place on August 28th, you didn't even announce to employees how they could go about getting an exception until October 14th, right?
Well, I think you're misstating my testimony. I said we knew we were going to create a process. I don't think we knew what that process was at that point.
So you were still coming up with it during the end of August and through September?
Yeah, we were gathering feedback from the different sources that work group that was put together, being led by Chief Recovery Officer Farnham, talking with other appointed authorities about their needs and what they were hearing from their employees. There was an employee survey that went out at some point. I mean, we were in a information gathering and synthesizing that to make sure we were hearing the concerns and addressing concerns.
So what you're saying is you were making decisions impacting the lives of thousands of state employees while the train was already out of the station, after the announcement was already made that they were coming back. You did not have those plans made up front, did you? I'll withdraw the question. As of August 28th, 2025, the governor's office, the agency of administration did not have a plan as to how to implement the exception process. Is that right?
The exception process, but we are also talking about how we're going to utilize the reasonable accommodation, which is a pre-existing process, how we were going to utilize alternate work schedules, which are there, and then also aware of the flexible work statute as well, and making sure we were in being guided by that as well as we move forward. And so we were in a planning phase.
A planning phase after you had already announced the December 1st deadline.
Well, we've been criticized many times of announcing.
I asked you an yes or no question. You were still in the planning phase after you had already announced to employees that they had to come back to their workspaces on December 1st. You were still working on your plan after that announcement, correct?
As would be normal operating procedure, given we've been historically criticized of making a decision, implementing the planning, and then announcing the solution without gathering input. Here, it was important for us to announce a change that was coming up out many months, and then how to roll that out and take in feedback from the various staff and departments and agencies that were going to be impacted. That happens regularly in state government.
So you were gathering information to figure out how to implement something that the governor announced in a press conference on August 7th.
In response to a question, yes.
Prior to the governor's announcement in that press conference, or the question that he answered on August 7th, were you aware that this was coming, this return to commute?
We were aware that, I was aware that conversations were happening about making changes to bring staff back more based on what the governor felt and others were seeing, like that we needed to make this change in similar ways to why he did.
Did you see any data that the governor relied on prior to making this announcement on August 7th?
I will answer your question this way, because I can't speak to what specifically the governor reviewed or didn't review, but I know that the governor received a confidential report from appointing authorities every Friday that documents trends or concerns or highlights things happening across state government. And that he reviews that over the weekend and normally comes back and asks follow-up questions, which usually comes back through the agency of administration or directly to other appointing authorities. And I'm aware, because we contribute to that report, that there were concerns that we were not normalizing operations in a way that felt like we were meeting the needs of Vermonters.
So that sounds like a no. You were not aware of the information that the governor was relying on when he made that decision.
I can tell you, I know what gets passed up to him that gave me concern, and I'm assuming he would have seen the same things and came to the same, but I can't speak for the governor.
Okay, I jumped ahead, but we're gonna now head back to Exhibit 13. So looking to the bottom of this memo, and again, we're looking at the September 5th, 2025 memo from Secretary Clark, is that right?
Yes.
Looking to the bottom of the first page, she highlights some areas of focus that the advisory group was looking into. Do you see that, those three bullets?
Yep.
And
Yes,
one of the areas they were looking at was office space and capacity planning. Is that right?
correct.
And that's because at that moment in time, there was not sufficient space set up for all of the workers to come back to their in-office locations. Is that right?
Yes, we just spoke about that just a few moments
We
ago.
sure did. Moving on to bullet 2. Impact on employees with extended commutes. As of September 5th, 2025, again, there was no protocol that employees could follow if they had concern about their commutes. That hadn't been announced yet, right?
No,
Okay. And the next one is impact on employees located out of state. You are aware that there were a number of employees who lived out of state, right?
correct.
And you've become aware, have you not, that certain employees were hired by the state with full knowledge that they lived out of state and wanted to remain living out of state. You're aware of that, aren't you?
I wasn't aware of certain employees being hired. I'm aware employees were hired during the pandemic that lived out of state, but I know that because after the fact, but I didn't have contemporaneous knowledge of those hires.
Do you recall Commissioner Fastigi testifying about those kinds of employees in her testimony to the House Committee in May of 2023?
I didn't see her testimony. I saw the PowerPoint.
Members of the board will reserve our right to provide a copy of that testimony. Curious whether it would be easier for the board to merely have the video testimony downloaded, or would you prefer that we have it transcribed?
I'm a little confused about what can we put on a flash drive?
We could submit it on flash drive, sir, but it's an hour and a half worth of testimony, right? And so I'm presuming it might be easier for the board if we provided the video to also provide the transcription for ease of reference.
I think that would be the case. Yes.
Then we will endeavor to do that by the next day of hearing.
Thank you. Just while everybody takes a breath here, it's 12:15. I would suggest we break for lunch at 12:30. If you can manipulate your question such that there's sort of a break at that time, that would be helpful.
Absolutely.
15-minute warning.
Thank you. As we think about it, we'll likely ask the board to take administrative notice of the hearing, and we will still provide the links to the hearing and transcription. I don't necessarily think that it requires any evidentiary ruling by the board. Okay, we're still on Exhibit 13, sir. Underneath the 3 bullets on page 1. Well, the document speaks for itself. Let's move. I will skip over the message from Governor Scott. Looking at Exhibit 15. You were copied on that letter, correct?
Yes,
And this was the letter from State Director of Labor Relations, John Berard, to VSEA Executive Director, Steve Howard. Is that right?
correct.
Are you aware of any correspondence from the Department of Human Resources to VSEA about this change prior to this letter?
My knowledge, I'm not aware of any.
Okay. Skip Exhibit 17. If you can move to Exhibit 18, please. This is the September 25th, 2025 memo from Secretary Clark to employees. You see that, sir?
Yep.
So there is what appears to be a hyperlink under the words information and resources to frequently asked questions. So by this point in time, the agency had created an FAQ, as it's called, to keep employees apprised of the answers to questions that were coming up.
Correct.
And that FAQ continued to be added on to as time went on.
And refined, yes.
Moving on. I will move you to Exhibit 20. And what I'm seeing is the October 3rd, 2025 memo from Secretary Clark to state employees. Is that right?
Yes,
I'd like you to help me make a connection between hyperlink we see on this page. Do you see the links to an out-of-state employee guidance document?
yes.
Okay, I'd ask you to turn to exhibit 22 and let me know whether that is the document that was linked from exhibit 20.
Yes.
Thank you. So at this juncture, in early October, the administration has now come up with the guidance that would apply to who are remote working from an out-of-state location, correct?
Correct.
And this would cover anyone who was living and remote working from out of Vermont, regardless of the distance?
No, this was directed to someone who wouldn't be able to commute reasonably within, because we have lots of employees in district offices that live out of state. Like we have district offices in St. Johnsbury, Hartford, Springfield, and Brattleboro, where we have a significant number of employees that might live in New Hampshire, across a river and commute to the office and are able to meet the standard without any issues. We also have employees that live in Massachusetts that work in offices like in Brattleboro, Bennington, and conversely, we have employees who live in New York and commute to the Bennington district offices or the Rutland office, or to facilities like the correctional facilities as well. I mean, so we employ a fair number of employees who live within easy commuting distance to their work location in Vermont, but reside out of state.
I'm curious, when you talk about easy commuting distance, did you have a range of miles or time in mind?
I think, when I use reasonable, I use it from my perspective. So I don't think, those are people who had been coming into the office a couple days a week or had been making the commute.
To juxtapose that, then you are aware that you could drive for 3 hours or more within the bounds of the state of Vermont. There are such distances within the state, correct?
Well, I'm well aware of that because as I testified earlier, after the 2011 tropical storm, my commute doubled for almost a 5-year period. And I worked and I didn't telecommute on a regular basis. So I was either in the field or in the office. So I'm well aware of the commuting distances.
And so this guidance, which is exhibit 22, that would not have applied to you despite the fact that you had a rather large distance to travel within the state, correct?
Correct.
So looking at this guidance, or considering the top of page 2, is it correct that the administration indicated that any employees who lived out of state would be required to meet the hybrid standard no later than June 30th, 2026?
That was exhibit 22 at the end.
Yes,
I'm
22.
sorry. I
No,
was
that's
looking
fine.
back at- Yep.
Take your time.
Yes, that's what, yeah.
Okay. And looking at page 1 of exhibit 22, the procedures for existing employees who lived out of state, they actually had to commit to relocating well before June 30th, 2026, correct?
For planning purposes, we wanted an understanding of what employees were willing to relocate or not. And it started that conversation.
And I think 3 lines from the bottom, the date identified was November 21st, at which time out-of-state employees had to communicate in writing whether they would meet the standard.
Yes.
All right. Moving on, we have Exhibit 23, which we talked about earlier in your cross-examination. This, again, was the first time that the administration announced the exceptions policy, correct?
Yes, for out-of-state employees, yes.
So looking toward the bottom of the page, we see the subheading new guidance. Then we see a sentence that starts with the word new guidance, and then another paragraph that says, as is the case for out-of-state employees. Do you see that paragraph?
Yes.
So I'm just going to read this first sentence. Let me know if I've read it correctly. As is the case for out-of-state employees, if all essential functions of the position can be performed remotely and compelling reasons, such as one of the following circumstances exist, exceptions to the standard will be considered. Did I read that accurately?
Yes.
So as of October 14th, 2025, the state was telling employees that they must have a compelling reason in order to have an exception to the 3-day in-office requirement. Is that right?
Correct.
And you gave some examples, but I think you testified that they were not exhaustive, right?
Correct.
But you do agree, you may feel familiar, you agree that words have meaning, correct?
Of course.
And the word compelling has meaning, correct?
Yes.
And someone who wanted to work more than 2 days remotely had to have what you described as a compelling reason, correct?
Correct.
So that would have to be more than mere personal preference. It would have to be some heightened reason why they needed to have that exception. Is that fair?
Yes.
And just to again connect the dots, we see some hyperlinks to the exception process on the second page. There is a link to employee exception guidance. Can you confirm for me whether the document as Exhibit 25 is that hyperlinks to documents?
Yes.
Thank you. Mr. Chairman, I believe that I would be moving on to a new area of consideration. This might be a good breaking point.
Let's break until 12:15. Welcome back. Welcome back. Let's begin again.
Thank you, sir.
Before we resume, I would like to just place one thing on the record that we neglected to do this morning. We would like to request sequestration of witnesses in connection with this hearing.
And we have no objection to that. There was an understanding that our client, Mr. Howard, who is a witness in this case, is our client and would be remaining. And we understand that the state will have at least one representative per day that they are going to have staying as well.
And there are no witnesses in the room at present. Let's go.
Thank you. Mr. Brown, back to where we left off was Exhibit 25. So this again is the exceptions guidance that was originally issued in mid-October of 2025. Is that right?
I believe so. Yes.
So I wanted to point your attention to the second page of the document. Under the heading procedures for requesting and determining exceptions. Do you see that heading?
Mhm.
Yes.
Yes.
Thanks. So first sentence says, employees may request an exception using the Department of Human Resources exception request form. These forms should be submitted by 11/21/25. Did I read that correctly?
Yes,
So putting aside whether the administration would accept another means of request other than this form, this particular document says that that is the way employees may request the exception. It's the only thing described in this form, right? In this document.
yes,
And it has a specific deadline, November 21st, 2025, right?
yes.
You became aware during this period of time that some employees had made exception requests on forms other than the exception form that the state had provided. Is that fair?
Correct.
And regardless of what the state's position was about how those should be handled, is it not true that you became aware some employees had their request rejected because it was on the wrong form, at least initially?
Not the wrong form. I think my testimony was that the appointing authorities said this is likely not going to be granted, so don't submit it. It wasn't because it was on the wrong form.
Okay, then let's stick with this document that's in front of you now. There is a deadline of November 21st, 2025 on this document, right?
Yes,
So at the outset in mid-October, that's the deadline that the state was requiring for people to submit their request forms.
yes,
But that changed over time, did it not?
it did.
At some point, the state determined that it would accept these exception request forms even after the deadline of November 21st, right?
Yes, and ongoing.
And ongoing, correct?
Correct.
And some of that change was as a result of some correspondence that the state had with the Human Rights Commission about their concerns. Isn't that right?
We heard concerns not just from the HRC, but we heard it from others as well in terms of making sure we were flexible. And so we made changes based on feedback from multiple sources.
Who else gave feedback aside from Human Rights Commission?
You know,
If I could
my
please finish my
apologies.
question.
Yes.
Who else, aside from the Human Rights Commission, gave feedback as to the either the type of form being used or the deadline?
My memory is when we were meeting with HR field managers, one of the meetings, they shared that they would recommend communicating out that 11/21 was not a hard deadline, and that there was, we'd heard there was confusion out there, so we wanted to clarify guidance, and we wanted the guidance to be supportive to employees and not be a hard deadline. So, on multiple fronts, we decided to clarify the guidance.
And among those multiple fronts was the communication that the state was having with the Human Rights Commission.
Yes.
I'd ask you to turn with me to Exhibit 40 in the binder. Take a few moments to look at that document and first let me know if you recognize it.
Yes.
And what do you recognize this document to be?
This is a letter from the executive director of the Human Rights Commission, Big Hartman, to Secretary Clark, and it's dated November 24th, 2025.
And how did it first come to your attention?
I believe Secretary Clark shared a copy with me after she received it.
And this is a document in which the executive director of the HRC expresses some question or concern about the process. Is that fair?
Yes.
And is this one of the pieces of information that the administration took into consideration when deciding how to modify the exceptions process going forward?
Yes.
Does it appear to be a true and accurate copy of the document as you remember seeing it?
I believe so.
We would offer Exhibit 40.
We would object to the relevance of this other thing.
Overruled.
turn next to exhibit 41, if you would.
Yes,
Have you seen this document before today?
yes.
And when did it first come to your attention?
As the letter was being finalized by Secretary Clark.
And does it appear to be a true and accurate copy of the letter that Secretary Clark wrote back to Director Hartman?
Yes,
Union Office 41.
Same objection.
And overruled.
Turn to the next tab, if you would.
42.
42, yes.
Yes.
So I'll first ask you to look at the first 2 pages of that document, which appear to be a letter from Executive Director Hartman to Secretary Clark. Have you seen that document before today?
Yes.
And how did it first come to your attention?
At the time it was being final, shortly after it came in from Executive Director Hartman, it was shared with me by Secretary Clark.
And the copy that's in front of you, after the 2-page letter, does it also have copies of pages of transcripts?
Yes.
Could you take a few moments to look over that transcript and let us know if you recognize what this is a transcript of?
Appears to be a transcript of my testimony from the injunction hearing at the Superior Court.
And again,
I'm
if you could
sorry.
just speak up,
Yeah.
could you repeat that?
It's a transcript of my testimony from the civil action in the Superior Court.
And I'm not sure if we actually stipulated that that hearing took place on the 26th of November. Can we stipulate that?
We can stipulate that, yes.
Thank you. All right, so the union offers 42.
Same objection.
Overruled. There's some likelihood of probative value here, so.
All right, Mr. Brown, I'm rounding the corner to the end of the examination and have some questions about exception reviews.
Mhm.
You indicated that there is an exception review team, and you spoke a bit about that team. Are you a member of that team?
I am not a member of that team.
And so the information that you have about the number of requests that have been received and reviewed, from where did you obtain that information?
Chief Recovery Officer Doug Farnham, who is chairing or a part of that committee.
And is it Mr. Farnham who indicated to you that there had been 610 requests received?
Approximately, yes.
And when did he make that statement to you? When did he give you that approximate number?
I have been asking for periodic updates just to understand what's come in. The last update was requested the other day and I received the information this morning.
I'm sorry, did you say this morning?
Yes, yes.
And
I'm trying to model how you should be
I
speaking.
appreciate that. I just am not used to speaking loudly. My apologies.
the number of requests, which you indicated was approximately 610, had that number changed over the last month or so?
My understanding is that it has slowly grown. We have from the hearing in November that we were just talking about until now, it has continued to grow.
As relates to the numbers of approvals, you indicated that approximately 127 had been approved to date.
That's my understanding.
Has that number changed in the last month or so?
I believe slowly increasing, yes.
And yet at this point, none of the requests have been denied. Is that correct?
Correct.
In terms of the process, as relates to the ones that are still pending. Some of them have been pending for a number of months, correct?
Correct,
A number of these requests actually came in by the original November 21st deadline, right?
correct.
And so as relates to those requests, the committee, the exception review team has already received all of the documentation supporting that request, correct?
That's my understanding, correct.
And so we're just waiting for them to either render a decision or announce that decision?
Will they make a recommendation, again, similar to the appointing authority, and then it goes up to Secretary of Administration, who's the ultimate appointing authority, who makes the decision on those exceptions.
If you know of the remaining 480 some odd requests that have been put in but have yet been ruled on, are any of those currently pending before the secretary, having already had a recommendation from the team?
I believe there are some pending final review by the Secretary,
Do you have any knowledge as to approximately how many of those there are?
not specifically.
Could we have just a moment? That's all I had. I would pass the witness back to the state.
Redirect.
Thank you. Just a few points to go over. You were asked on cross about the number of days employees were working based on teleworking based on Beth Vestigi's testimony in 2023. Do you recall that?
Yes,
And I believe some of that testimony compared that to the 1 or 2 days that you were testifying about when the policy was first implemented. So I wanted to clarify, when you were speaking of employees teleworking 1 or 2 days per week, what time frame were you speaking of?
that was from the time the policy was implemented in 2012 until the start of the pandemic. And
And then that shifted during the pandemic.
correct.
I also wanted to turn to the December 1st, 2025 date for the hybrid work standard. Are you familiar with the provisions governing termination of telework under the telework policy?
Yes, there's a notice provision.
And how much notice are employees entitled to?
2 weeks, I believe, is my memory without looking at refreshing my memory from looking at the policy.
Yeah, please turn to Exhibit F.
Okay.
And specifically case number 0015.
Yes,
And based on that, what amount of notice is generally given to employees for termination of telework?
it says whenever feasible, either party will provide a minimum of 2 weeks' notice of the decision to terminate telework participation.
That's all I have. Thank you.
Nothing further.
Questions? You,
Any questions?
questions? Cool. Well, I don't do, no, question.
I'll just jump. You have,
Want to know when the guidance to employees went back out after the Human Rights Commission recommendations. And things changed on 11/24. When were the employees notified that there would be changes?
They were notified in the weekly update. If it was immediate after, I'd have to go back and look at the records, but after those correspondence and final decisions were made on updating the guidance, that was communicated out to employee usage from Secretary Clark on either a Friday or a Monday.
So that was really close to that December 1st deadline that was coming. That was from 11/24, and it was the next week that that was when.
It would have been updated because of the correspondence with the HRC director. My memory is that correspondence went into early December when the clarifications were sent, and we were, yes.
It may be helpful just to, maybe in briefing, just to reference whether or when employees were notified of the change in the deadline, if that occurred, and how they were notified of that change. That'd be helpful, just so we can.
Absolutely.
I have a question. Several times in your earlier testimony today, you used the phrase normalized operations, and usually in the sense to a return to normalized operations. The term normalized operations, what is there a standard definition of that across state government?
I don't, that's a term I was using in reference to state government significantly shifted how it operated at the start of the pandemic and through the first year or so of the pandemic in terms of restrictions of how many, like of who could be in the buildings, remote work, telework, suspension of rules of how we administered programs or delivered services. There were a significant number of exceptions to our rules made so that we could have a continuity of government and delivery of services. And as we moved through the pandemic and vaccines, we hit thresholds of like 80%. We started relaxing those and returning to our existing rules and leaving that state of emergency. And so that's what I'm referring to. Like things started to normalize. More people started coming back to the office. We started administering our rules, the original rules that existed before the pandemic, in terms of like needing this type of interview or processing it this way, an application. So a lot of changes were made to meet the needs during the pandemic, to how we operated.
So is it fair to say that what constituted normal and normalized operations varied by agency or by building or by geography? What constituted the norm of normalized relations?
It would have looked different for different agencies and different types of facilities. Like correctional facilities had certain restrictions in terms of visitation and the wearing of masks and health and safety standards, versus the waiver of rules for eligibility, like no longer needing a face-to-face interview. Those started to be eased, and you needed to start having those interviews with individuals. So it did look different depending on what agency or department you worked for.
And again, we've heard the use of telework policy and hybrid work standard. What's the distinction between the two?
The telework is that bargain policy that sets up that framework of how we would approach telework. Our hybrid, like there's been testimony today and acknowledgement that we had staff working fully remote, and then we had staff working fully in person. And under the new hybrid work standard, we were returning to a mixture where everyone was being asked to be in the office 3 days a week and being allowed to telework 2 days. So it was a hybrid approach between all remote and then that people who've been all in person could still have an opportunity to telework if they wanted to under this new standard.
But, but still there always was, and there always is still that group of employees whose work will always have to be in person. I assume, again, we've talked about corrections as the primary example.
Correct. But there are also other employees who chose not to telework. I mean, many during the pandemic did, but again, I not just because it's my reference point. Like during the pandemic, I still went to the office every day pretty much and worked in the office. Many times I was in the Waterbury complex by myself, or with maybe just a few other leadership positions. And other employees chose to do that too. And then I've continued that myself to be in person 5 days a week and only occasionally telework when something pops up and I need to be closer to home for something. But and there are a group of employees that have always chosen to do that.
And speaking of a group of employees, at one point, there was a reference to a group of 610 employees. Can you refresh my memory about what group that is?
So those are employees who have submitted exception requests to be exempt from complying with the new 3-day in the office because they have personal circumstances that they believe warrant that. And those are what we were just talking about in cross-examination. Those staff, until a decision is rendered on their exception request, are still able to work under their pre-existing work schedule, like at home. Like say if someone before 12/1 was working from home 5 days a week, they're still able to do that until there's a decision on their.
And that's based on their pending request.
Yes.
Should we think of that group as the entire universe of employees who have an interest in continuing telework, or is it a subset?
I'd say it's I'm not quite sure how to answer that. I know we have all the other staff that want to telework. We have thousands of approved new telework agreements now from staff who are complying with the new work standard. Whether they're all happy about that, I can't testify to that, but
I understand. Thank you.
I just want to follow up on that. For those who had applied for the telework under the 3-day provision for whatever reason, but now that you've extended the deadline for exceptions, could they now apply for an exception?
yes, and we're still getting new requests that come in based on some of them. Their circumstances have changed, or they've decided they want to now seek an exception, even if they were complying. We are still having new requests trickle in.
So why the delay in issuing approvals or denials? Does it have something to do with our proceeding?
No, it's a very individualized review, and there are many layers to that. And with the ultimate appointing authority, Secretary Clark being the final approver, it's just the time and the time of year with the budget and everything else. It's just a very slow process. And that's the reason we've also allowed staff to continue with their pre-existing work schedule, because we knew going in that this was going to be a slow and time-consuming process. So those 610 folks are still working their old schedule and are until we have a final decision. And I would say even when we ultimately come upon one that we feel we should deny, it will not be just a denial and you're back to work. Like we will have an interactive process with that employee to see if there's other ways we can support them before having them come back. And also just making sure that we have all the information that's current too, because we've actually had some back and forth on like we had a request come up. I'll use this as an example that came through. I'm aware of this because we spoke about it. She shared it with me. Secretary Clark is who I'm referring to, where an exception came up and was recommended for approval. But the approval didn't go all the way to the requested point. I think it was only granted to a like maybe April or March. I can't remember the specifics, instead of the June date that the staff recommended. And then Secretary Clark approved that. And then based on a communication from VSEA saying, hey, did you guys make a mistake? What happened here? And then we went back and re-reviewed it and actually updated the approval through June, you know.
Okay. And in terms of the exceptions, your response raised a question of mine. There are, at least from some of the materials, there's long-term exception and a short-term exception. Could you explain the difference between the two? And then I'm going to ask you, where do those 610 folk fit? Like, if you were to grant their request for an exception, is that only good until June 1, or is that indefinitely? Is that indefinite?
Well, they're all set for a set time period, but there will be a review before they terminate, before that date comes. And if there needs to be an extension, that'll be part of the process.
Is that set time period June 1?
That it's either June 1 or June 30th. And some are different based on the employee's request. Some employees ask for only like through May or June, and so they're not all one date.
And the notice materials that went out to employees, were they informed that they can request an extension that goes beyond June 1, or was it just to June 1?
I'd have to go back to refresh my memory from the guidance that we sent out, but I know we talked about it and acknowledged early on that this was going to be an iterative process, and that we were going to need to be aware that circumstances could go beyond that date, and that we needed to have some flexibility built in the process to support staff. Because I mean, I've been designated the appointing authority for AOA. So like when it comes up through before it goes to the secretary, I'm the appointing authority for any that come up through the agency of administration. And I know I've approved some or recommended approval where, based on the circumstances, that person is going to need an extension based on their circumstances beyond the original time frame. And that's what, before that happens, we're going to be reviewing those, because they're the reason we like the form electronically is we have all that data now captured, and we can report out on it and track it and monitor it much better than we did before the pandemic.
Okay. I may not have the right date. One of the earlier emails or notices from Secretary Clark, she indicates that there's going to be a survey. And then later there's, I think it's in early October, she might have provided the results of that survey. What was the purpose of the survey? If you know.
We want to engage staff and give them an opportunity to provide feedback, but we also, it was to gather our data was not as comprehensive as we hoped. And so by surveying our employees, we felt like we'd get much better accurate data. That was one reason. The other, as we were looking at, we were starting to hear anecdotally that some employees might have taken a job further away from their home with the expectation that they would continue to telework. And one of the questions we asked was commuting distance. And so we wanted to understand, from our employees, like what would be their commute returning to the office, and how many fell into different categories. And so we asked a series of different questions just to understand kind of what our current workforce was thinking, and certain data points.
Did you use the survey to inform your exception policy? The survey results?
Yes, and we use a lot of other pieces of information as well.
Okay, so the survey summary that's provided in Exhibit 21, which is the October 10th email from the secretary to, I guess it's all state employees, survey results. Some of the takeaways were commuting time, one-way commute, and other challenges But the exceptions that were listed as examples in the exceptions policy were military spouse relocating, court-ordered arrangements, or relocation for personal safety. None of the items that were included, at least in the summary of the survey results, were included as examples of reasons for qualifying for the exception. Is there a reason why they weren't included?
I think at the time we were originally adopting that, we weren't fully aware of all the circumstances. And so we just put as examples out. It wasn't an exhaustive list. That's why we used the phrase such as, because we felt like employees would tell us what was when we put the request out, people could apply, because we didn't limit it to, we just said, everyone, if you feel you have a compelling reason, let us know. Submit a form. We didn't limit the submission of forms to anybody, nor did we limit it just to those categories. We didn't know what we would get from employees. And so that's why the process is taking a while, because we have left, we're reviewing each one very individually on the merits for that particular employee.
Okay. And in Exhibit 23, when describing the exceptions, they're listed as limited exceptions. What does the modifier limited mean? It's in the second paragraph. It's 14th memo.
Yep, I'm looking, yes. Okay. Think what we were trying to convey with the word limited is that we did create this new standard because we felt operationally it was important for staff to be in the office 3 days a week. But we also recognize that staff have circumstances where that might not be possible, and that we wanted to offer the opportunity to apply for those exceptions. And that it wouldn't be just, and you could get one just because you wanted one, that there had to be some reason why you couldn't come to the office 3 days a week, because we felt, because it's an important part of the work to be in the office was the expectation.
Okay, so that sounds more like the compelling reason. So there needs to be a reason other than the employee doesn't want to come to the office for 3 days a week. It needs to be
Correct,
more than just I want to. But I'm trying to understand the limited part. There are limited exceptions. That it limited suggests a finite amount, and it's as if, was there an expectation, or did administration anticipate certain types of that would qualify as an exception when that was drafted?
I think we had certain things in mind that we were aware of based on feedback we had received early on. Like we received some feedback from the Vermont Commission on Women. And so we wanted to make sure, like the domestic violence concern. And so we were trying to be responsive. We knew that list was not exhaustive or complete. And that's why we used the word such as, and then getting additional input from our HR managers and appointing authorities and the HRC, we continue to expand and clarify that guidance. So people understood that, 11/21 was not a hard date, nor was there an exhaustive list of reasons. Felt they needed an exception, they should submit it, and we would review it on its face for that individual employee.
When you were talking about the Cherry Street state office in Burlington,
Yes.
You had mentioned that the state's got approval from the legislature to sell it. How many Vermont state employees were working there? If you know.
I'm going by a very distant memory here, so I'm happy to get more details. So that building had a combination of what I would say would be like central office staff for the health department. And then there were also what we would call field staff or district office staff who provided direct client service, like someone coming in applying for a benefit, like economic services. Staff were in 108 Cherry Street. Health department had district office staff there, but also that's where their central office was located. And I believe there might have been some other staff in the building as well. And my memory is, and this is by memory, and so, but I can get, it's like there might have been 300 staff in that building, maybe not quite, but I'm not. And what we, for the district staff who needed to be in Burlington to provide that in-person client service model, the state leased a building down towards the south end of Burlington, off like short. I can't remember the specific address, but there's an office there, like where we have district office staff from different divisions or departments located. And then many of the central office staff were already teleworking remotely, most full time at that point when we moved the district office staff out. So there wasn't a significant disruption at that time to those staff because many of them had already been working remotely due to the pandemic and and then the existing telework policy. And it was, as I testified, it had always been a long-term goal of the Agency of Human Services to consolidate all of its central offices of its departments into Waterbury.
Mhm.
And this was the opportunity that provided that.
And when did that, and they're all located in a leased facility?
We did lease another building in Pilgrim Park in Waterbury where we have already leased space. And so that space is the space we were talking about that's being fitted up, and the expectation was that it would be available in February.
Okay.
Yeah.
Right, thank you. Just going to check my notes. When you were with the Office of Child Support, I think you had talked about that you actually reviewed a couple of telework. And maybe I just had a note. Did you review any telework requests at that time?
I'm sure I did, just given my position. I just don't remember the specifics. But
Do you remember denying any?
no, we were trying to support staff who'd been disrupted from the flood.
When you were talking about reviewing exception requests, I think at various times the ADA was referenced or ADA accommodation requests. When you're the universe of 610 folk who are waiting for an exception determination, are those folks separate and apart from anyone who's made a reasonable accommodation request?
Yes.
Okay. Do you know how many folk have made a reasonable accommodation request?
I believe several hundred at a minimum. I don't have the exact number.
And what's the status of those?
Those are
people?
still, again, those staff are working their pre-existing schedules while the interactive process works through on those cases. That's being managed centrally by the Department of Human Resources and their pre-existing team that does that work.
Okay. Do you know if any of them have been denied?
Not to my knowledge. And I do know that we have actually, there's a number of exception requests that came in as exceptions. And when you look at why they were requesting it, it became clear that it was probably more aptly a reasonable accommodation request. And we referred them so they could be considered under that process as well, which is different and can be and that is a much longer different process.
Do you know if any have been granted?
I could get that data from you at this point, but I don't have that at my fingertips.
And I apologize. I'm still just trying to figure out who is on the review committee, and maybe I'm using the wrong term to describe the committee, who is reviewing the exception request.
Making the recommendation. Yeah, I've made a call.
Okay,
And we're that and the lease space question of like beyond the Pilgrim Park, we were asked if there were additional buildings. And I've made a call to get that information. I don't know if I'll have it by the end of the day, but we have, I have made the request for that data.
and do you have an understanding or definition of what a compelling circumstance would be or is under the policy?
I think it varies depending on each individual request. Like,
I'm sorry, I didn't get that.
each individual request. I mean, we're leaving it to staff to tell us what their circumstances are. And, we gave some examples, but we've received others that are things we didn't expect to see.
Understood, but I'm just trying to get a sense of how the committee is evaluating those requests. I'm sure they don't want to be arbitrary about it. There are likely some factors that they consider. So in terms of compelling, what are some of the factors or indicators that might support granting or denying?
Yeah, like we're seeing where someone who has a partner who works a job that has very they need to be in person and like say in the healthcare industry, and they're not very flexible. And so their hours there really make it impossible for that partner to be there for the children at certain times of the day in terms of maybe getting to school or getting back from school. And so we've had employees ask, can I work an alternate schedule or can I be home these days and beyond the thing so I can be there to make sure my kids, those are some of the things we're seeing. Make sure your children, we've seen someone whose spouse is very ill, significantly ill, and they need to be there to support that person. Those are pretty clear to move up the process with a recommendation to approve.
Mm-hmm. And have you come across any that appear clear that they don't warrant granting an exception?
I've not personally, from the one I've reviewed, I've not seen that. I saw one where I just needed a little clarification to understand a little bit more. And then once that clarification became very clear, because sometimes we're trying to be sensitive also, like these are sensitive matters to staff too, and they're sharing some details that probably aren't the most comfortable. And we want to be very respectful of that. And that's why we're guarding this process. And these are very highly confidential forms for that reason. And
I think that was all that I had. Michelle.
I have some questions that are related to the area that Ms. Dillon was just covering. This review committee that decides on exception requests, is its composition consistent, or is it on the other end an ad hoc committee? The makeup of the committee, is it in fact consistent?
Yes.
From request to request?
yes. Yes.
And how many people are on the committee, if you know?
I would need to get that. I'm not sure of the exact number. I can get that for you.
Well, let's say it's easy. Let's say it's five people.
Yeah, it's not a significantly large group, but
Would that mean that all requests are considered and either approved or denied by the same 5 people.
That committee doesn't approve or
I,
deny.
I,
They make a
handed
recommendation.
up
Yeah,
the chain
yes,
of
yes,
command to
yes,
the authority
Yes,
by the same 5 people.
yes.
And to your knowledge, does the committee use a particular rubric or set of standards, if you will, by which they measure or consider, approve, or to recommend exception requests?
I think they're using the standard that what's being described to them by the employee as a barrier to being in, does it prevent them from meeting the standard, and does it fall within like that type of reason where we feel like it outweighs the public interest of being in person and serving Vermonters in person, where we believe that there's increased value to that. And if the answer is yes, then they grant that. And the reason we're having one set group do that is so that there's consistency from how they're being handled and reviewed and approved, so that we don't have, someone with a similar situation in the agency of agricultural being granted, but yet someone in the agency of natural resources being denied for very similar reasons. We don't want to be treating staff unfairly or differently in similar circumstances.
Thank you.
Do all those exceptions have a termination date where it ends?
Yes, many do, and they vary based on the staff request.
So are any of them open-ended because it's something that's going to be going on, like a sick spouse that could be sick for years?
Right, and some of those we've approved. Some are vary within a couple months, because they just need to make some changes and be able to come into compliance with the new work standard. Others we've granted to a date, but with a note like, hey, we understand that this is a longer term thing, and we can reevaluate as that date gets closer of where you're at, what your circumstances are.
Ms. Phelps, do you have questions for the witness?
I do not at this time.
That be the case? Thank you very much.
They might have questions based
Any
on our
other
questions.
questions here?
We have a few.
Please.
I would yield to the stage. Whose witness it is.
I
The
thought
state goes first,
I thought I heard a no.
but they're conferring.
Do you have a decision?
If you could turn to exhibit 25.
Here.
And under procedures. Sorry. Under the heading procedures for requesting and determining evidence.
Mhm.
The deadline, November 21st, 2025. When it says these forms should be submitted by November 21st, 2025, was that intended to mean that it was mandatory? Was that intended to advise employees that that was when they should be received?
I'm sorry, I didn't hear what the last bit of your question.
Or was that intended to advise employees of when the form should be received?
I'm going to object. That question could not have been more leading.
It could have been.
Well,
I stand corrected.
I'm not sure we need to go there.
Okay.
Would you like to rephrase?
What's the deadline of November 21st, 2025? Intended mandatory?
It was not mandatory. We always understood, and we could have been better about communicating that. And then we did communicate better about that. But some of that was just wanting to get a sense of the universe of requests coming in. What did they look like? And so that we understood what some of our employees were grappling with, and to whether they could comply with the state. And also knowing that we knew it was going to take a long time for us to get through those forms just because it is very individualized and there's a process. And so we didn't want to be a hard deadline. And we also recognized that this is an ongoing policy and that this was just the initial trying to like move things along, but that the fact that we still get new requests is there, and you know, they're not nearly as numerous as they were initially, but we continue to get new requests.
Thank you.
Other questions from the state?
That's it from the state. Thank you.
The union.
Thank you. Could you turn with me to exhibit 36, please?
6.
Do you have that, sir?
Yes.
This is one of the memos from Secretary Clark to the staff, correct?
Yep.
Can
Yes.
you, tell us the date on this one?
This was Tuesday, November 25th.
At the bottom of page 1, there's a bullet point called telework request.
Yes.
Could you read aloud that bullet?
Unless you have requested a reasonable accommodation and or have a pending exception request submitted by November 24th or otherwise authorized by your appointing authority, if you have not received an approved telework agreement, you are expected to report to your assigned work location 5 days a week until an authorized telework agreement is in place.
So as of Tuesday, November 25th, the deadline was November 21st, correct?
Yes.
Right.
Yes.
Okay.
Yeah.
And anyone who did not have a request in by that date was expected on December 1st in the office 5 days a week, right? Is that a yes?
Yes.
Okay.
That was-
Getting then to follow on to the questions from the board about when and how the members were notified that the requests for exception would be taken even after the deadline. Turn with me to exhibit 38, please. What is the date of this memo from the secretary?
December 5th.
So this was the week after the November 25th announcement?
More or less. Yes.
Right. In the intervening time, there was the Thanksgiving holiday the prior week, yes?
Yes.
And the state was closed on Thursday and Friday of that week, correct?
Correct.
So we had the Tuesday, the 25th announcement. We had a Wednesday that you and I spent together in the Superior Court, and then the state was closed Thursday and Friday, right?
Correct.
Okay, and then the next week, this is the weekly memo from the secretary.
Yes.
All right, so this would have been the first opportunity for the secretary to inform employees that the time frame for exception requests has been extended, right?
Yes.
And on the bottom of page 1 of exhibit 38, without having said this any other time that I can see, the secretary says, please remember, you can continue to request telework agreements exceptions. Do you know of any time prior to that, writing that sentence, when the secretary or anyone else told employees that they could continue to request exceptions?
Well, I know we started socializing this with other appointing authorities and asking them to share this before we got the formal communication out. So
Was that over the Thanksgiving break? Was that early that week? When was that?
I can't specifically recall the specific conversations and the date, but
And you have no control over that socializing, right? That's you may have asked managers to start talking to people, but you have no way of controlling that kind of socialization, right? Correct?
no,
No, that's not correct, or no, you do not have that ability.
I do not have that ability to control other people's communications.
So then the only communication that we can point to, or the first communication that we can point to where the state is telling employees they could continue to request exceptions was after December 1st.
My memory, and I'd have to look at my transcript, but I believe at the hearing, I may have said that was not a hard deadline.
So anyone who might have been watching or attending that Superior Court hearing might have heard you say that. But other than that, there was no announcement prior to December 5th from the state to employees that the exception deadline of November 21st was an open-ended deadline. Withdrawn. Docs can speak for themselves. Last bit of questioning. You had some questioning from the executive director about the requirement of compelling circumstances. I believe you agreed, regardless of how that's defined, that compelling circumstances is still the requirement for an exception of this. Is that yes?
Yes.
Okay. And the communication from the state has consistently said to employees that you will have to have some kind of compelling circumstances in order to get an exception.
Yes.
And you have heard stories that some employees have self-selected out of the process because they thought their circumstances were just not compelling. You've heard of those, yes?
I have not heard of those.
You've not heard of any employee who has self-selected out?
Not that I'm aware of, but what I've heard of is employees who went to submit an exception request early in the process and were told that would most likely be denied, so don't submit it. And then we intervened and with those appointing authorities that were involved in that to correct them, and that they're not to prejudge any request.
That's fine. We'll put on employees for that point. The last thing I would have then is, well, on that point as well, are you aware that some employees have actually left state service because of the requirement that they have to come back these number of days per week?
I have heard that. I don't have personal knowledge of that.
And so in terms of compelling circumstances, you answered the executive director's question by indicating the types of requests that you have seen, including spouses with health conditions. And you also mentioned something about children, drop off and pick up for children with a spouse who has arrangements that cannot be altered. Has that kind of request actually been approved?
I would have to look at the approved forms to tell you exactly what's been approved to date.
Nothing for
If I may just briefly. Could you turn to VSEA's exhibit 35, please?
Yes.
Under the heading hybrid work standard request should be made by the end of day tomorrow. If you could read the third sentence of the first paragraph under that. Based on that information, was it communicated to employees that they could submit exception requests after November 21st? This.
Yes. Yeah. This says if, to ensure, we're able to accommodate them by December 1st, we were asking them that, but it doesn't say it's a hard deadline.
And doesn't it say that submissions after November 21st would still be considered?
Yes.
So when in exhibit 38, in that paragraph that tells employees to please remember, is it?
Which paragraph?
No, I'm sorry, the last paragraph, Bates number. These are Bates numbers, but the last paragraph on the first page.
Excuse me, which Bates page are we on?
It doesn't have a Bates number, but it's VSEA exhibit 38. The bottom of the page, the last paragraph. The begins to date we have received.
Thank you. That sentence says, please remember, you can continue to request telework agreements, exceptions, alternate work schedules, and reasonable accommodations by speaking to your supervisor or manager or through the Department of Human Resources forms.
So this memo, what is that please to?
Other guidance that had been sent out and communicated out that exceptions were not couldn't be requested past that date.
Thank you.
I'm sorry, I just have a clarifying question. So the exhibit 35 says you can submit a exception request after November 21, but you still, if you do that, you have to report to work 5 days a week on December 1.
Yes, and I don't believe we enforced that provision. That's what we relaxed and modified our standards.
And someone is going to, is there an exhibit where that expressly was revoked or modified or relaxed?
I don't know if there's an exhibit here. I know we tried to get the word out through appointing authorities to let staff know that if they filed an exception, they can continue to walk their old standard. And we've actually had requests come in even as just recently where we've allowed staff to go back to their old schedule, even though they were complying with their new the new work standard of 3 days in the office. So they've submitted exception. We let them go back pending that request, even though they were already complying with it. So it's not a static process.
Okay. All right. Okay.
Okay, ask one follow-up on that. Is there guidance available to employees on the internet?
Yes, we've advised early on for staff to periodically check the DHR website where we provided on the links to all the documents and where they were posted, because we were updating them frequently. As we learned and made new decisions, we updated those documents frequently. Sometimes even before the communications went out that information was there, because we wanted to get it posted because we knew staff were visiting that website for information.
So would those updates have included information about
Yes.
The fact that they wouldn't have to report?
Yes.
They had an exception request pending after November 21st.
Yes.
No further questions.
Questions?
No more questions.
None. Yeah.
Thank you.
Thank you.
Thank you.
We would reserve the right to call us witness in about it.
Let's put that for you all.
Respectfully, Chair, we have not gone over kind of logistics for a remote witness. Opportunity to just talk that through for a second. Okay. So the union's going to call for our first witness, a brief witness who can not appear on any other day. And so we're going to take her out of order. I need to contact her so she can join the room. And then once she does that, I thought that I would log in to the room as well and share the exhibits on the screen. And on my screen, we have 2 exhibits that there is no objection to them. But just so that the witness sees what we see, if that's okay.
That's fine.
Yes.
And I'll do my best to emphasize what you're sharing, or you can.
I have the good fortune of not having a recent issue, and so I'm very loud. I've never been told that I couldn't be heard.
Oh, no, I wasn't doubting that. I was to make sure that they see the exhibit, because there are a lot of folk.
Oh, I see.
Yeah.
That's what I meant. And I think I control the emphasizing, and I'll emphasize.
And how will we see the
Whomever you-
exhibits?
We
Well, they're
have them.
already in.
We have them.
You'll
We have, all
Yeah.
right. So we have-
So
May I ask a follow-up question? If we need to show one of their witnesses the document that's not heard, what would be the best way to do that?
I would do it the same thing. See, what should have happened, folks should have had the exhibits presented to their witnesses before this.
Oh, she
Yeah.
has it.
Oh,
There's
she does.
her exhibits there. Yeah. So she is, well, she's aware of them.
Okay. So she has the state's exhibits also?
Well, these would be, say we needed a document for impeachment person.
Okay. Got it. Then you would need to share. You could share. Yeah. You can share.
And I'm happy to too, if you don't want to have to log in and do it, because I have
Okay.
all of our exhibits. So
Okay, let's do it that way. So just, you'll come in as your name, and we can actually, it's about 2:30, maybe we can take a break and we figure out these logistics and come back in like 10 minutes or so.
All right.
Does that make sense?
10 minutes?
Yeah.
Would that be sufficient?
Yes.
Yeah.
Okay.
Okay, good. Union will call its first witness, please.
Yes, the union called its first witness, Jessica Stevie.
Good afternoon, Ms. Stevie. Can you hear us?
I can, yes.
Good. I have, excuse me, I have two things for you. An oath and then some instructions. First, the oath. Do you solemnly swear or affirm under pains or penalty of perjury that the testimony you shall give relative to the cause now under consideration shall be the truth, the whole truth, and nothing but the truth?
I do.
And some instructions. These are instructions regarding remote testimony. Unless directed by me as the Labor Relations Board chairperson, when you are testifying, there should be no one else in the room with you, and there should be no one in your location able to overhear your testimony. You may not consult with anyone during testimony. You should have access to the exhibits about which you will be testifying. You should not look at or make reference to notes or any other documents or materials other than the exhibit to which you are testifying, unless allowed to do so by the board. Any devices used by you when testifying should only be used to view the exhibit to which you are testifying.
Yep.
Clear? Great.
Clear.
Let's
Thank
begin.
you. Okay, hi Jess. I am going to ask you a few questions now. So what do you currently do? Where are you currently employed?
So I'm currently employed in the AHS Central Office, and I am a Finance Manager 3.
And so is that with the state of Vermont?
It is, yes.
And so tell me a little bit about what does a Finance Manager 3 do? Very high level. What do you do?
I guess very, very high level for my specific role is I do the comprehensive Medicaid claim for the state to the federal government to get us our money back.
Okay, and does that involve primarily internal contacts or external contacts in your day-to-day work?
So it's both. I work with all of the departments within the state of Vermont, and I work with external, so the federal government, CMS, Center for Medicaid Services.
Okay, so let's talk about those internal contacts first. Are those only located in one area of Vermont or in multiple areas of Vermont?
As far as I know, they are all over. So DIVA, DMH, the usuals.
Could we have those acronyms?
Yeah.
Sure.
Yeah.
Do you know what? Yeah, go ahead.
Yeah.
You know.
Yep. So DIVA is Department of Vermont Health Access. DMH would be the Department of Mental Health. I work with VDH, so Vermont Department of Health, DCF, which I think everybody is pretty familiar with, Department of Children and Families, DALE, Department of Aging and Independent Living, DOC, Department of Corrections. I feel like I might be missing one. I think that's
You
all.
can come back.
And then
you can come
okay.
back to it. So your testimony is that those various agencies are not in a centralized work location. Is that correct?
As far as I know, yes.
Okay. And you mentioned that you have external contacts too with the federal government. Do you happen to know where those external contacts are located?
I know that 2 of them are located in New York, but I can't recall the name of the city.
And so when were you hired for this position?
I was hired in October 2023.
And do you recall who hired you?
Yes, so it would be Marie Hayward, who's my direct supervisor, and then Tracy O'Connell, who was the financial director at the time, and then Rich Donahue, who was the CFO for AHS Central Office.
And is Tracy O'Connell, is she still at the agency that you work for?
She is. She actually took over for Rich's job. Rich has since left, and Tracy is the new Rich.
And what is her current position again?
It is a CFO.
And where do you live?
I live
town?
in Derby, Vermont, and we are probably a good 30 seconds from the Canadian border.
Okay. And did you live in Derby, Vermont? Did you live in Derby, Vermont at the time of your hire?
I did, yes.
And you said that Miss Hayward and Miss O'Connell, and I'm sorry, Rich's last name again?
Donahue?
Donahue. When, if ever, did you have any conversations about with them at the time of your hire about where you live?
In the initial interview, I had mentioned that I lived in Derby and that it was a lengthy commute, but we discussed the telework option.
And so can tell us about that. What did and if you remember with specificity who said it, please tell us. But what was your expectation about your telecommuting from that process, from that on?
Objection. That was just a lot of questions. All in one compound.
Okay, so you testified that you were hired by those three individuals and that you had a conversation about where you worked. Do you recall with any specificity, like can you describe the conversation that you had where you talked about where you lived?
Yes, it was also a little over 2 years ago, so it's sort of hard to remember, but I do remember discussing the telework option and that I would be able to come into the office only 2 days a week and then telework 3 days.
Okay. And would you have accepted the position if you had not been given the option of that you were given at that meeting?
No, probably not.
And why not?
My commute to the office is probably about an hour 35 to an hour 50, depending on both weather and the season.
And so where is it that your office is located?
My office is in Waterbury.
And so you said that you began working there in October of 23. What was the expectation when you started working about your need to come into the office? How often?
I was asked to come into the office 2 days a week.
And did that did you in fact do that?
I did, yes.
How long did you do that?
About a year, and then the telework agreement changed to 1 day in office.
Okay. And you were about to say something about did you say weather? But I want to give you an opportunity to finish that.
Yes, I came into the office 2 days a week, weather permitting. So if the weather was not good, then I did not drive into the office.
And what if any what was the process for you to be able to not come in if the weather was not permitting? Who did you have to talk to?
I talked to my direct supervisor, Marie.
And were you ever denied if you said you needed to work from home because of the weather?
No.
And you just testified that the expectation of in-office time changed at some point. Do you recall when that expectation changed?
I do. It was January of 2025.
And do you recall if you ever memorialized in some way that expectation of your telework arrangement?
Yes, I signed a telework agreement.
Bear with me for just a second as I show you an exhibit by sharing my screen. Just all right, I'm going to scroll through this document.
Which exhibit?
It's exhibit 54. And Jess, do you recognize this document?
I do.
Okay, what is this?
This is the telework agreement that I signed in January 2025 for moving to 1 day in office.
Okay. There's been no objection, so this is already admitted into the record. I'm just going to ask you a couple of questions about this document, and then in the middle of it, the first page, I see a schedule here, and that there every day but Wednesday has some times. Can you tell me why does Wednesday not have a time frame as the other days do?
Yes, so Monday, Tuesday, Thursday, and Friday, those all have times because those are the times that I would do remote work. And Wednesday didn't need that because I was in office on Wednesday.
And we can look at this document, but what was your expectation about what the end time for this arrangement would be?
I didn't have an end for this. We left it blank because it would potentially change or it might not. So it would have to have been a conversation that we would have had, and we didn't have one.
And now I want to show you one little, just to clear up this discrepancy here, perhaps. On the third page, there's a number of signatures with dates, and the first signature block, is that your signature?
Yes.
Okay. And so it says 1/9/2024. Is that accurate?
No, it should have been 2025. It was the new year, and I was used to writing 24.
Okay. So it's your testimony that you signed this on 1/9/25.
Correct.
Correct. And then before this time, had you ever signed a telework agreement with the state of Vermont?
Yes, when I first got hired.
Okay, but you no longer have access to that, is that correct?
That's correct.
All right, so was your in-office expectation, did that ever change again?
Not exactly. I did hear, yeah, that there was a return to commute mandate.
And about when did you hear about that return to commute mandate?
I want to say it was sometime in August, but I can't recall which day.
Okay. And what was at the time that the return to commute order was presented to you, what, if any, exceptions to going back to the office did you understand to be the case?
When I first heard about the return to commute mandate, I wasn't aware of any exceptions that would have been approved.
And then did that change?
It did a couple months later.
And did you ever have any conversations with your manager about that exceptions process?
I did. I saw the exceptions,
So first, can you tell me who you had the conversation with?
yes, with Marie Hayward, my direct supervisor.
And tell me how that conversation went.
We had regular one-on-ones every Tuesday, and I discussed my concerns about the return to commute mandate, and the exceptions didn't fall under anything that I would have been approved for.
Okay, and so did you said that to Marie?
No, she said it to me when I filled out the form.
Okay, I'm going to show you another document here, so bear with me. It's admitted as VSEA Exhibit 55. You see that document?
I do.
I'm going to scroll through it. Do you recognize this document?
I do.
And what is this?
This is the exception request that I submitted to Marie in October, asking to stay with my current schedule of 1 day in office.
Okay, and was this the document that you discussed with your supervisor?
It is, yes.
So let's talk about that discussion. What was, if you can summarize for us, what was the reason that you were requesting an exception to the 3-day-a-week standard?
Primarily, my request for the exception was safety reasons. It's over an hour and a half one way, and especially in December, roads are rough, and Vermont has a lot of small highways. So safety was my biggest one.
Okay, and did you tell that to Marie?
I did.
Okay, and what, if any, response did she have?
She was sympathetic, but what I was requesting as an exception didn't fall into the bullet points that we had received in the memos. So she did not think that it would get approved.
And so after filing this exceptions, what, if anything, have you heard? At first, did Marie submit your exceptions request?
She did.
And how do you know that?
She told me that she submitted it.
And what, if anything, have you heard about your exceptions request?
I haven't heard anything.
So in the interim, since filing your exceptions request and now, do you have any anticipated changes to your job?
Yes, today is my last day with the state of Vermont.
And so can you tell us, why is today your last day with the state of Vermont?
I had a lot of anxiety over the 3-day mandate and being forced to drive into the office in such a long distance. And since we hadn't heard anything about the exception, I started looking at Indeed and ZipRecruiter and all the other options and started interviewing and was offered a job.
So when will you start that new job?
On Monday.
Congratulations.
Thank you.
Okay, just give me 1 second. No further questions.
You. And so, Ms. Stevie, I don't think we've met. My name is Wendy Chen. I'm an Assistant Attorney General representing the state here, and I'm going to ask you just a few questions. And I just want to confirm, you been a state employee since October of 2023. Is that right?
That's correct.
And would you agree that it's your responsibility as a state employee to know and follow all state policies and procedures?
Yes.
And are you familiar with the state's telework policy? That's telework policy is policy number 11.9.
Yes.
And you, I believe, testified that you asked to telework under that telework policy in January 2025, as well as prior to that.
Correct.
And in your initial request, was that to work remotely 3 days a week?
Yes.
And how long, and that was approved, correct?
Yes.
How long did you work on site 3 days a week? Wait, I'm getting it backwards. On site 2 days a week, wait. Correct. On site 2 days a week, telecommuting 3 days a week. How long did that last?
A little over a year.
And did you ask to work one additional day per week remotely after that? Or did your supervisor or manager make that request?
My supervisor had started working in office only 1 day a week, and she offered it as an option for me, and I absolutely took that up.
And is that why you signed a new telework form in January 2025, which is at Exhibit 54?
Yes.
And the state approved that request, correct?
Correct.
And I do want to maybe have Kat screen share Exhibit 54 again for everyone to look at.
You can't me my plug. Like it's the end of it.
Thank you.
No, the other end. That's not plugged into my laptop.
So let me just ask you, Ms. Stevie, did you understand, based on the form and the policy we talked about for a moment earlier, that telework was a privilege that the state could revoke at any time?
Yes.
And looking at Exhibit 54, this is the telework request form you submitted and was approved. It actually does state on this form that telework is a voluntary program provided at the sole discretion of the appointing authority and may be terminated by the employee or employer at any time with or without cause. That's on page 1, kind of under the heading termination of telework. Do you see that?
Mhm.
Did I read?
I'm sorry, can you repeat the question?
Yeah, did I read it correctly that it states on this form, telework is a voluntary program provided at the sole discretion of the appointing authority and may be terminated by the employee or employer at any time with or without cause?
Yes.
And so you understand that was a condition of your teleworking agreement?
Yes.
So at any time after you submitted this form, were you required to work more than 1 day a week on site?
Required, no.
And tell me what you mean by when you kind of question the word required.
Yeah, we were informed of the return to commute mandate for 3 days a week in office, and there was a lot of confusion about whether we were required to in December.
So in December, were you required to work on site more than 1 day a week?
I was not, because I had the exception request in.
So I believe you testified that you did not receive a response to your exception request as of right now, correct?
Correct.
But in the meantime, you were allowed to continue teleworking just 1 day a week?
Correct.
And I did see that you kind of cited concerns about your safety in terms of winter driving conditions for your exception request.
Yes.
You would also testify, right, that in the past, even though you had were required to work on site generally once or twice a week, depending on the time period, you did not have to actually go in if there was poor weather or poor driving conditions. Is that right?
Correct.
Did you have any reason to believe that would change as of December 1?
I did have anxiety about it, that I would be required to come in at least 3 days a week, even if it would be snowy on a day that would be normally my day. I would be required to come in on a different day.
Were you ever given information that led you to believe that actually that wouldn't be required and that you might still be allowed by your supervisor not to commute in on a regular in-office day if there was bad weather?
The communication was very confusing, so no.
Are you familiar with the term called ad hoc telework?
Yes.
Can you tell me what that means to you, your understanding of it?
Ad hoc is as needed.
And do you have an understanding of, under the state's policy, when ad hoc telework is allowed?
I believe it's just under weather, severe weather. That's my understanding anyway.
Did any of your supervisors or managers or anyone or higher levels tell you that ad hoc telework was not going to be allowed after December 1?
No, again, everything was really confusing for the communication. So even my supervisor wasn't sure what the plan was.
Did you receive as a state employee a series of memos and emails from the Secretary of Administration about the new hybrid work standards starting December 1, 2025?
Yes,
Did you review those emails?
I did.
Did you go to the Department of Human Resources website to look over some of the linked materials from those emails?
Yes, I did.
Did you recall if any of that material that you reviewed addressed whether ad hoc telework for situations like that, whether would still be in force after December 1?
I don't recall.
I think those are all my questions for you. I appreciate your being here, Ms. Stevie.
Thank you.
Redirect.
No redirect. Thank you, Jessica, and thank you
Wait,
for your service.
uh,
No.
I-
Oh, go
The
ahead.
board may have some questions.
Sorry.
I know it's quick, but recross?
No.
No?
She,
They're done.
No?
Yeah.
They're done?
Wait,
Questions?
I don't know.
Questions?
I don't
Um,
have
I-
any.
I'm just curious, but for the change in the policy, would you still be working at the state of Vermont?
I would. Yes, I wouldn't have been looking elsewhere.
Thank you.
The witness is excused. Thank you, Ms.
Thank
Stevie,
you.
and good luck. Another witness?
Yes, we will begin our examination of Steve Howard.
And just before we begin with this witness, as time moves on here, just notice from either party about deadlines for the end of today's proceeding, or when we should aim for a close of our business today.
We're at your disposal on our side. I expect that the direct examination of Mr. Howard may take us to the 4 to 4:30 timeframe. And so it may be that we have to begin his cross-examination on Monday.
That would be a natural break. Would that work? All right, let's shoot for that. We'll see how it goes.
Maybe I'll go faster and we'll start cross-examination soon.
Okay. All right. You've called Mr. Howard. Mr. Howard,
Hello.
good afternoon.
Hi.
An oath. You solemnly swear or affirm under pains or penalty of perjury that the testimony you shall give relative to the cause now under consideration shall be the truth, the whole truth, and nothing but the truth. I do. Thank you. Welcome.
Good afternoon. Can you state your name for the record, please?
Sure. Steve Howard,
And what, by whom are you employed?
Vermont State Employees Association.
And that's the same organization that is the charging party here in this case?
That's correct.
What is your job title with the Vermont State Employees Association?
The executive director.
How long have you been the executive director of VSEA?
Since June of 2014.
What did you do prior to June 2014?
I was the legislative director starting in December of 2012.
Were you employed by VSEA prior to December of 2012?
No.
What did you do before coming to VSEA?
I was employed by the Chittenden County State's Attorney's Office.
And prior to that?
I was a member of the Vermont House of Representatives, and I had a private consulting business.
When you were a member of the House, what committees do you recall sitting on?
Served on the House Institutions Committee, the Commerce Committee, and the Ways and Means Committee, also the Transportation Committee.
The Institutions Committee that you just mentioned, is that the same committee that Commissioner Fastigi testified before in May of 2023?
It is. It's now called the Corrections and Institutions Committee, but it's the same committee, different members.
And when you served on the committee, what was its function?
It's primarily to oversee state property and state buildings.
And did you take testimony from the leadership of BGS during that period of time?
We did.
And what kind of business did the committee undertake with regard to buildings that are leased or owned by the state?
Sorry, could you repeat that again?
Sure. What kind of business did the committee have to undertake with regard to leased or owned properties?
Primarily, we were concerned about capacity and the condition of the buildings and projects that were being proposed, renovations, new buildings, that kind of stuff.
Do you recall the years that you served on that committee? What period of time?
Yes, it was January of 1993 till sometime in 1994.
Recognizing that it was a good couple of decades before the telework agreement even came into effect, did you, as a member of that committee, develop any opinions on the on workplaces where state employees were then performing work.
Yes.
What conclusions did you draw about the state of affairs of state workplaces?
There was never enough parking. The space, there was always a lack of space. And we heard a lot about the condition of the buildings.
You recognize that in the time since you left that committee, different buildings were built and renovated and leased over time.
Yes.
So let's move back to the VSEA. Can you describe for us the structure of the VSEA?
Sure. The VSEA has a board of trustees that's elected by the membership. It's led by the president of the VSEA. There are officers that are elected by the members. There's a council of elected members that is a sort of a check on the board of trustees. And there's the executive director, and we have a staff of roughly 20 people.
Sorry, that was 20.
That's correct.
Thank you.
So let's just clarify those different groups that you mentioned. The board of trustees is made up of members of the organization who are elected,
That's correct.
and the legislative council is made of members of the VSEA who are elected to those roles.
Some are elected and some are appointed.
And as the executive director, to whom do you report?
Report to the board of trustees.
And are you a member of the VSEA?
No,
You're an employee of that organization.
that's correct.
You mentioned that there was a staff of roughly 20. Are those staff members dues paying members of the organization, or are they employees of the organization?
They're employees of the organization.
How generally is the staff organized?
There are 5 departments at the VSEA. All of those departments report to me.
What are those departments?
Excuse me, I'm just going to ask you to speak to Attorney Florian when you're answering, just so that your voice is
Can you-
projecting this way. Thank you.
Sure. Can you ask the question again?
Yeah, I'd asked you what those 5 departments were, and I'll scream at you to remind you to scream at us.
See if I don't forget any of the departments, right? So we have the operations department, the field services department, communications department, the legislative and political department. And we also have I knew I was going to forget one, legal department and communications department. I said that twice, but
The record will reflect that you did.
yeah.
Okay, in terms of the different functions that the VSEA performs for its members, let's start with negotiations, either of collective bargaining agreements or interim agreements. What group or groups are involved in negotiations with the state over conditions of employment?
There are 3 bargaining units that bargain with the executive branch: the non-management unit, the supervisory unit, and the corrections unit.
Before, I'm going to interrupt my own question and ask you something else before we get to this. What other bargaining units aside from NMU, corrections, and supervisory does VSEA represent?
It's testing me now. We have the judiciary, we have the Vermont state colleges, the housing authority, the transport deputies, the office of state's attorneys. I think I've gotten them all.
Okay, turning back to the 3 that you mentioned up front, the non-management unit, who belongs to that unit?
The largest unit, it's basically all of the state employees who are in the bargaining unit that aren't supervisors and who don't work for the Department of Corrections.
Then it may be self-evident, but who belongs to the corrections department, the bargaining unit?
Any employees who work for the Department of Corrections,
At least those who are unit eligible.
who are unit eligible, right?
And who belongs to the supervisory unit?
Those are the supervisors in state government.
And are those 3 units the units of the state executive that you represent?
Those are the 3 executive branch units.
And so back to my original question, which was when you're negotiating on behalf of any of these three units, the executive branch units, who on the VSEA side, what group or groups of people are involved in those negotiations?
There are two groups that the negotiations are led by members of the VSEA who are elected by their unit to represent them on the bargaining team. And they are assisted by VSEA staff.
And what VSEA staff members would be involved in assisting in negotiations?
Our Director of Labor Relations, Gary Hoadley, is the lead negotiator. And he is assisted by either senior union representatives or the Director of Field Services, Gretchen Naylor.
Could you spell Mr. Polte's last name?
Mr. who? Mr. Hoadley?
Gary, yeah.
Hoadley. I was watching. I hope I didn't misspell his name.
The last name you mentioned. Oh, we got the record for a moment?
But I didn't.
Maybe.
Yeah.
You can even put it at the end of your tables as well.
Don't move.
Got to speak to BGS about getting you some new tables.
Start with the new room.
Yeah.
Big.
Okay, the last, you mentioned senior union representatives, is that the title you mentioned?
That's correct.
And what department at VSEA do those people work for?
Senior union representatives have sort of a dual role. They serve as union representatives and they work in the field services department primarily, enforcing the contract. And then for the purposes of bargaining, they work under the Director of Labor Relations.
And I believe you already mentioned this, but in their role with field services, who do they report to?
Gretchen Naylor,
Spell her last name.
Naylor.
When we think of the directors that you mentioned Gary Hoadley, who's the Director of Collective Bargaining. To whom does he report?
To me.
And Ms. Naylor, the Director of Field Services, to whom does she report?
To me.
And I believe your testimony was that those staff members assist some elected group of people. Is that right?
That's correct.
And so the bargaining teams, is there one bargaining team across the executive or different ones for the different bargaining units?
There are 3 different bargaining teams.
And when there is a proposal from the executive branch that might impact all 3 teams, how does the VSEA handle negotiations?
It depends. They generally, you can have joint negotiations on issues that are common throughout the 3 bargaining units. But there are times when the units decide not to work jointly and to negotiate separately.
All right, I'm going to turn your attention to the time frame of the original telework policy. Those discussions began in or around October 2011. Were you employed by VSEA in October 2011?
I was not.
I'm going to ask you about some names of VSEA listed individuals that show up in exhibits A through G. I'm not going to actually pull the exhibits in front of you. I'm just going to give you the names and see if you recognize who they were at the time. Mike Casey, do you know who that is?
I do.
Who is that?
Mike was the general counsel at VSEA, and at different periods, he was the interim executive director.
We also see some communication regarding Gretchen Naylor. Do you know what job she held at the time?
My recollection is that she was a senior union rep at the time.
We see reference to someone named Kathy Partlow. What was she doing at the time?
My recollection is that she was also a union rep.
I'm also looking at in Exhibit H, which is a press release from VSEA. There's someone named Lucas Herring, Herring, who's identified in this document as the chair of the VSEA NMU Executive Committee. What is the VSEA NMU Executive Committee?
Bring my knowledge to the test here. The VSEA NMU Executive Committee is the committee of members that are elected by the NMU unit to run the business of that unit,
An NMU,
non-management unit.
All right. When you came on board with VSEA, at some point did you become aware of policy 11.9 relating to telework?
Yes.
I believe you testified that in the year 2013, you were the legislative director of VSEA. Is that right?
That's correct.
Do you recall during that period of time, the legislature passing and the governor signing the flexible working arrangements statute?
I do.
As the legislative director for VSEA, were you involved in lobbying the legislature around that statute?
Not that I recall.
So in the period after the flexible working arrangement statute took effect, and after you became executive director of the VSEA, what position did the VSEA take at that time with regard to the requirements of the telework policy in relation to the existence of a flexible working arrangement statute?
We understood that the decision-making process was a local decision-making process made by the supervisor involved and the appointing authority. We understood that it was that there was no arbitrary component to it. There was no limit on, for instance, the number of days you could be approved for telework. We knew that it was a case-by-case policy that was dealt with each employee seeking that. And we also knew that the approval that the agreement had to be, it could not be inconsistent with the operation of the department or the agency.
Okay, let's move on to telework prior to the onset of the COVID pandemic. As executive director of the VSEA, did you have some understanding of the how extensive or non-extensive telework was prior to the onset of COVID pandemic?
I did.
What was your understanding?
My understanding is it was rare and it was infrequent. Just a different group of employees who had a different model.
What do you mean by that different model?
Just different generational expectations.
And what were the expectations that the bulk of your membership had around that time frame?
That you reported to a work site.
And did something perhaps of worldwide import change that expectation?
Yes.
What would you say that was?
The global pandemic.
When do you remember that beginning?
2019, 2020.
So let's turn our attention to March of 2020. And again, what was your job at VSEA by March of 2020?
I was executive director.
And so when the governor issued Executive Order 01-20 on April 15th, 2020, you were executive director at that point?
I was.
Objection. I'm not sure the date, where that date comes from.
Exhibit I, which is in record, says on the last page, this executive order shall take effect upon signing. And oh, I'm sorry, the date, I may be wrong about that date. My apologies. Oh, please. Undated policy. Okay, well, we'll move past that. In March of 2020, when the government, do you recall any orders that the governor gave with regard to the state workforce?
Yes.
What do you recall of that?
I believe, what I recall is that the order was, for those employees who could work remotely, that they would.
And in that regard, what kinds of employees who are represented by VSEA would not be able to work remotely?
The nurses at the psychiatric care hospital, the nurses and the medical staff at the vet's home, correctional officers, employees for BGS, Billings and General Services. There are some AOT employees who also had to report. Probably more, but those are the largest ones that I remember.
And as these impacts of the pandemic were becoming well known, what position did VSEA take with regard to what the state should be doing?
We believe that the state should be as aggressive as possible at protecting the health of our members and the public.
I will ask you to open that binder in front of you and turn to a document marked State Exhibit K. You see what that document is?
Yes.
What am I looking at?
Looking at a letter from our then President Dave Bellini to Governor Scott.
Tell us where that document is.
Yeah,
I'm not getting
I
it
think
under
we-
K.
It's in the black binder. Is it in the black? Yes. K is in Kathy or King. Kathy could be with the same.
Sure. All right. Do you recognize that letter, Steve?
I do.
Do you recognize the signature on the bottom of that page?
I do.
Whose signature is that?
Dave Bellini,
And who was he at the time?
President of the VSEA.
Did you have any involvement with the drafting of this letter?
I did.
What was your involvement?
I drafted it.
Fair enough. Okay. At some point, our long national nightmare started coming to an end. When the governor began making orders related to returning to in-office settings, what was VSEA's general position with regard to how that should be accomplished?
It should be accomplished consistent with the policy and the flexible working arrangement statute.
And when you say that the return to in-office settings should be done in accordance with the policy, what policy are you referring to?
Policy 11.9.
Turn your attention to exhibit T as in terrible.
Okay. There we go.
Turn to the second page of this document. Toward the bottom of the page, there are several paragraphs under a heading telework moving forward and next steps. Do you see that?
Yes.
The second paragraph of that section indicates that employees should be submitting requests in accordance with policy 11.9. Did VSEA object to that requirement?
No.
If you look at the paragraph above the subheading, telework moving forward and next steps. You see the paragraph that begins, an employee is not precluded?
Yes,
Can you read that first sentence out loud, please?
an employee is not precluded from requesting approval to telework anytime in the future beyond November 1st, as the telework policy is intended to provide flexibility for state employees throughout their careers with the state and for use as individual circumstances and preferences change.
And did that comport with your understanding of what the telework policy was at the time?
Yes.
Turn to the next document, which is Exhibit U. And if you'll turn with me to page 4 of that document.
And that's you as an umbrella.
That's correct. I might have said uvula, just for fun.
Uganda.
Do you see the section entitled Supervisor Responsibilities?
I do.
Can you read aloud the 5th bullet point that begins with the words the supervisor makes?
Supervisor makes recommendation for approval or denial. The final approval for telework is through the appointing authority or their designee.
Does that comport with the union's understanding of what the policy was at the time?
Yes.
And when employees were transitioning out of the height of the COVID pandemic and the workplaces were reopening, were you aware of any limitation on the number of days that employees could request to telework?
That was not.
We'll turn to the next document with me. That would be V as in vapid. Before asking you about this, anything in this document, I wanted to ask you about your understanding of whether employees, whether there existed any VSEA members at the time who lived out of state but worked remotely for the state of Vermont.
Yes, there were employees who lived out of state and worked for the state of Vermont.
And we understand that some of those employees may live near the border and actually work on site in Vermont. Were you aware that there were employees, or are you aware whether there were employees who lived out of state and worked remotely?
Yes, I was aware.
Can you turn to page 4 of this telework FAQ document? The third box down from the top, the second full box, has a question on the left that says, can I telework from another state? Do you see that?
Yes.
Can you read the first paragraph of the answer to that question?
If you would like to live out of the state of Vermont full-time and be employed by the state of Vermont utilizing telework, you must seek approval from the commissioner of your department with final approval from the secretary.
Did that comport with your understanding of the policy as it existed at the time?
Yes.
All right, I am going to move forward to October of 2024. Could you please turn in the binder to exhibit EE, electric elephants?
EE. Oh,
Okay. Take a moment to look over this email message, and after you've done so, let me know whether you recognize it.
I do recognize it.
And what do you recognize this document to be?
An email from Deputy Commissioner Miranda Gray to her staff in the Economic Services Division, Department for Children and Families.
How did this document first come to your attention?
Sent to me by the president of the VSEA,
Who was the president at the time?
Amy Bertrand,
And what department did she happen to work in?
Economic Services.
When this came to the attention of the VSEA, did the VSEA respond?
Yes.
Turn your attention to exhibit FF, Friendly Frankfurters. What is the document we're seeing here in exhibit FF?
This is the letter from our general counsel to Commissioner Winters.
Well, first of all, was there some other response made to the state after Deputy Commissioner Gray's letter, or was this the VSEA's initial response?
This was the VSEA's response.
If you can turn with me to page 3 of this beautifully drafted letter. We see some numbers and letters on the bottom of page 3. What is that we're looking at in numbers 1 through 5?
Those are the items that we requested from the Department for Children and Families. Information we requested from them.
We'll round back to this in a bit, but did the union ultimately receive responsive information to that?
Yes.
Do you remember when that responsive information was turned in?
I believe it was in February.
February of 2025.
I think that's correct.
Okay, let's keep marching through the packet for a moment, though. If you could look with me at exhibit GG. Good God. What are we looking at in exhibit GG?
This is a demand to bargain from the VSEA.
I'm sorry, take a closer look at GG. Who signed that document?
Oh, I'm sorry. This is the. Hold on, let me just read it for a second, a little closely here. This is John Berard's response to our demand to bargain. Sorry.
All right. I'm going to draw your attention to 2 things in this document. Actually, I'll narrow that down to 1. The 3rd paragraph that begins with the word nevertheless. We see the 2nd sentence there that says, accordingly, the state is pleased to meet with VSEA with the understanding that neither party is waiving any legal positions it has regarding the matter. Had you seen that verbiage used by Mr. Berard in the past?
Yes.
And remind us who John Berard is.
He is the Director of Labor Relations for the state of Vermont.
And how does the VSEA normally interact with Mr. Berard? In what capacity?
We interact with him on a daily basis regarding issues that come up between negotiations, and we also negotiate with him when we're negotiating a collective bargaining agreement.
And with regard to this verbiage about neither party waiving any legal positions, was that common language for Mr. Berard to include in letters to you?
Yes.
And what kinds of legal positions is Mr. Berard referring to when he uses that verbiage?
That calls for speculation.
The recipients of this letter, the VSEA, had to have some understanding at least of what Mr. Berard was saying over the many years that he used this verbiage. So perhaps I'll ask the witness what his understanding was. Steve, what was your understanding of what Mr. Berard meant?
My understanding was that he meant that we would meet to discuss the matter without conceding our positions on the issue.
And what is the issue that was in dispute?
The return to commute for the Economic Service Division of Department for Children and Families.
And what was the VSEA's position with regard to whether the state had to negotiate over that at the time?
At the time, this is a letter in response to our demand that they bargain.
So the VSEA had demanded to bargain via my letter of several weeks earlier?
Yes.
And this was Mr. Berard's response to that?
Yes.
And you see here where in paragraph 2, where he, on behalf of the state, respectfully declines to engage in bargaining?
Yes.
So the parties at that point had a disagreement as to whether there was a bargaining obligation. Is that fair?
That's correct.
All right. Did VSEA meet with state representatives with regard to the ESD situation?
Yes.
Who from the VSEA participated in those meetings, or that meeting or those meetings?
I believe it was the Economic Services Division Labor Management Committee and our staff. And it may also have been the non-management unit bargaining team potentially. And it could also have been our Director of Labor Relations.
Did you participate?
I did not.
I think the one entity you named that we haven't already identified is the ESD Labor Management Committee. What is that?
That is in the contract, there is a provision for employees and management to establish a committee to meet periodically to discuss non-bargainable issues that are occurring in the agency or the department.
So getting back to the material, the information request that VSEA submitted to Commissioner Winters, I believe you indicated that we ultimately did get the information that we were receiving, that we had asked for.
Yes.
So I'm going to ask you to turn to VSEA Exhibit 10. And that would be in the white binders for the board. It would be 10 with a bunch of letters after it.
Yeah, it's 11.
Mr. Chairman, may I assist the
Oh,
witness?
I see it. I see it. I got it.
It's in, no.
10A.
10A is where we will begin.
In the white.
10A. Okay. 10A.
Yes, okay. Yeah.
So the first thing I'm going to ask you to do, Steve, is, even though it will take you a few minutes, might take you a few minutes, is to look at all of the sub-lettered categories in Exhibit 10, and let me know once you've thumbed through those. Let me know whether you recall seeing those documents before today.
And excuse me, that would be 10A through L?
Yes,
Is
that's
that
correct.
what L is the end?
L is in love.
Just to let you know, 10H has been admitted.
Yes, thank you. Madam Executive Director.
Steve, there are tabs on the side of the binder that are labeled.
That was Steve's executive assistant who made the binder pointing out what he was looking at, but we're all set with that. Thank you, Danielle. All right, you've been through two of the documents so far, Exhibit A and Exhibit B. Let me start with Exhibit 10A, since you've already seen that one. Have you seen that document before today?
Yes.
And how did that come to your attention?
It was in the information that was supplied by the Department for Children and Families.
Was that in response to our request for information
That's correct.
relating to the ESD situation?
Yes.
So I'll start there and offer Exhibit 10A.
Gonna object to that based on relevance. I'm not seeing the relevance to whether the state had a duty to bargain over the 2025 return to office, initiative.
Do you comment on relevance?
Sure. As I indicated earlier, the state has defended this case based on the ESD change. The state has suggested that the union waived its bargaining obligation in the 2025 change because it did not file any charges in 2024. The witness is going to look at these documents and explain whether they impacted the VSEA's decision at that time whether to file charges or unfair labor practices charges relating to that change, and also whether the union followed through on its demand to bargain as a result of the information that the state provided.
We would like to caucus. We're back. The objection is overruled. The exhibit is admitted. See.
Steve, then.
Excuse me, one other announcement. Our board member, Ms. Phelps, has a hard stop at 4:45. I know we said we'd shoot for 4:30, but just an early warning. We're at the very most 45 minutes away from stop.
Understood. Thank you, sir.
Continue to shoot for 4:30. Great.
May I inquire?
You may.
Moving on then, Steve, to Exhibit 10B. You've flipped through that rather lengthy package. How did that package come to your attention?
It was in the information sent to us from the Department for Children and Families.
In response to our information request related to ESD,
That's correct.
union offers 10B.
And then
You look at exhibit 10C.
is there an objection?
We're just gonna have a standing objection to the 10 series of exhibits
All
for the
right.
same reason.
Yeah, I thought I had covered it when I mentioned the whole package, but in regard to exhibit 10, proceed.
Understood. I'll re-ask the question then that was pending and with the largesse of my opposing counsel, I will ask whether 10C was also a document that you received from the state in response to the information request.
Yes, it was.
You'll notice that there is no tab 10D, E, or F. Steve, have you listened to the audio recordings that have been marked as exhibits 10D, E, and F?
Yes.
And were those audio recordings also received from the state as part of the information request packet?
Yes.
I would offer D, E, and F. Moving on to G. Steve, was exhibit G also a document you received from the state in response to the union's information request?
Yes.
For 10G. Moving on, 10H is already in evidence, so we can move on to 10I. And Steve, I'm just going to ask you to quickly look at I, J, K, and L. And after you've done that, let me know if these are also documents that VSEA received from the state in response to the union's request for information.
Yes.
The union offers exhibits 10I through 10L as well. Thank you very much, sir. Steve, to your knowledge, did DCF implement the return to commute for the ESD employees who were the subject of this correspondence?
Yes.
Did the VSEA file a grievance or an unfair labor practice charge at that time relating to that change for those employees?
No.
Why did the VSEA not file any charges?
Because we believe that the department was in compliance with policy 11.9.
You've testified as to your understanding of the policy and the related flexible working arrangement statute. Why was it that the VSEA believes that the ESD change was done in conformance with the policy?
It was done, it was a decision that was made locally by the appointing authority and the supervisor, deputy commissioner. It was specific to this unit. But mostly the evidence that we saw was that they believed that remote work was inconsistent with the operation of the department.
And how, if at all, did the information that the state provided to VSEA enter into that decision making?
Can you repeat that?
Sure. We just looked at exhibits 10A through 10L. How, if at all, did that information inform the VSEA's determination that there was no violation of the telework policy?
Our conclusion was that they had followed the policy as we understood it. It was made. It was not an arbitrary decision. It was made by the local, so made on a more local granular level for a particular unit, and it also, we felt they had met, they believed that the department, that the operations of the department were not being well served by that policy, by remote work.
And they provided evidence to that effect.
They did.
And that's what we saw in Exhibit 10.
That's right.
We keep going to see how much we can get through here. I've heard that the governor gave a press conference on the 7th of August in 2025. Did you happen to see any or all of that press conference?
I saw the news report that evening that reported on the press conference.
And what do you recall from that news report as to what the governor said was going to happen with regard to telework opportunities?
I believe he said that employees would be required to report to a work site for 5 days.
And did you actually see that news report on the day of the press conference, August 7th?
Yes.
Did you speak to anyone else that day about what you saw?
No.
What was the next conversation you had with anyone relating to the return to commute protocols?
On the 8th of August, I received some correspondence from members who had also seen the news coverage and who emailed me to make sure I was aware of it. And then late in the day, on the 8th, I got a call from the Secretary of Administration.
And who was that?
Sarah Clark.
Did you know Secretary Clark at all prior to receiving that phone call from her?
Yes.
How long have you been acquainted with her?
At least a decade. Forever. Sarah is like a fixture in the State House. So I've known her forever.
And have you had routine contact with her over the years?
Yes.
And have you had routine contact with her since she became the Secretary of Administration?
Yes.
What kinds of things would you two be in contact about?
We were in contact mostly about the severe staffing emergency in the Department of Corrections. We arranged for her to meet with family members of correctional officers so she could get an understanding of the depth and seriousness of that crisis. We met with members of the Department for Children and Families Labor Management Committee from the Family Services Division, so that she would have a clear understanding of the serious crisis we faced in the lack of beds for youth in the high-end system of care and the impacts it was having on our members.
So getting back to your conversation with Secretary Clark on August 8th, do you remember about what time of day it was?
I believe it was around 4 o'clock.
I'm hoping it was in the afternoon.
Yes, although I would be up at 4 a.m. I don't think she's going to call. She hasn't yet called me at 4 a.m.
Can you describe the phone call, please?
So the secretary called and she said that she was about to put out a letter to all state employees. And it was going to be in regard to what the governor had announced at the press conference the day before.
Did you respond to her suggestion that she was going to be putting out a memo that afternoon?
Yes.
What did you say to her?
I said that I did not think it was going to be warmly received. And that I asked her if she would wait until Monday, because at this point in the day, most state employees would either not see it or they would see it and then have to go through the weekend with the anxiety and all of the issues that it would provoke, really without anybody to call or contact.
How, if at all, did she respond to your request?
She said she didn't agree to do that. She said she had to send it out today.
Can you describe the secretary's demeanor during that conversation with you?
Yes.
Please do.
Sarah's a very competent person, and she's completely pulled, somebody who you just don't see as easily frazzled. She seemed to be a bit frazzled, and I got the sense that she was scrambling.
Is that unusual for her in your communications with her?
It's very unusual.
All right. I'm not going to walk you through all of them, but I'm going to walk you through a couple of the emails that came out. Let's start with Exhibit 11, which is the August 8th email from Secretary Clark to all state employees. Do you have that document, Steve?
I do.
Now, first of all, this document appears to be directed to all state employees. You are not a state employee, are you?
No.
How, if at all, did you come to possess these documents?
This was sent to me by the leadership of the VSEA and by many state employees.
And when you talk about the leadership of the VSEA, you're talking about member leaders?
Yes.
So people who are state employees and would have received this in the normal course.
That's right.
And so in this August 8th email, do you see any details about what the plan is going to be?
No.
I'm going to be to the next exhibit, which is Exhibit 12, dated 20 days later, August 28th. If you look with me at the bottom of page 1 to the top of page 2, do you see where the document states that Governor Scott is setting the standard at a minimum of 3 days a week in the office?
Yes.
Had VSEA received any notice of that prior to this email?
No.
Several lines lower, there's a timeline that says the standard would be effective December 1st, 2025. Do you see that?
Yes.
Prior to this, receiving this email, did the VSEA get any notice that that was going to be the time frame for this change?
No.
And by this time, August 28th, 2025, 21 days after the governor's press conference, had anyone from the state notified VSEA, either through you or the Director of Labor Relations, of this policy shift?
Not to my knowledge.
Who would normally be the person from the state who notifies VSEA of a proposed change in conditions of employment?
John Berard.
Had you received any correspondence from John Berard about this by August 28th?
I don't believe I did.
I'm going to turn your attention to Exhibit 15, please. What are we looking at in Exhibit 15?
This is the letter from John Berard that notifies VSEA of the governor's plan to institute return to commute.
Looking at the second paragraph that begins with the words nevertheless, and going to the very end of that paragraph, you see where it says the state is pleased to meet with VSEA with the understanding that neither party is waiving any legal positions it has regarding the matter. Do you see that?
Yes.
And what was your understanding based on your many, many years of correspondence with Mr. Berard about what that meant?
My understanding is that it meant that we could meet to discuss the issue with the understanding that neither side would concede their position.
All right. At that point in time, had VSEA seen any written policy about how the plan was going to be implemented?
No.
Had VSEA seen anything that we've heard about today with regard to the exceptions policy?
No.
Did VSEA ultimately respond to Mr. Berard's letter?
Yes.
I will point your attention to Exhibit 19. Do you see that?
Yes.
What is it we're looking at in Exhibit 19?
This is a letter from our general counsel to John Berard responding to the notification he sent on the 12th.
You see the paragraph, the second paragraph that begins with the words, "as you are no doubt aware."
Yes.
I'd like to take the time to have you read that aloud, please. That paragraph.
As you are no doubt aware, the state's announcement that it is requiring all affected employees to return to commuting to an on-site duty station has led to wide-ranging concerns, many of which have already made their way to you and to the governor's office. We are also somewhat hamstrung in that the governor and his team have, as of yet, failed to provide any details as to how they intend to accomplish this monumental undertaking in the very short time frame the governor has mandated.
Thank you. Noting the span of time, we see that Mr. Berard's letter was dated September 12th and the union's response is dated September 26th. Is there a reason that the union waited 2 weeks to respond to this letter?
Yes.
What is that reason?
We were sort of grasping for information, watching the emails that were coming from the Secretary of Administration, trying to figure out from those emails what the policy was supposed to be. And then we reached a point where we felt we couldn't wait anymore.
After the September 26th letter, did the parties hold a meeting?
Yes.
Do you remember the date of that meeting?
I believe it was October 10th.
Do you know what caused the meeting to take place then 14 further days after the union's letter?
I think there was a just sort of normal routine scheduling challenges between Mr. Berard and the folks at VSEA's representation.
Did you attend that meeting on October 10th?
I did.
Can you describe that meeting for the board, please?
Sure. It was at the VSEA, and we had representatives of the bargaining teams there, VSEA staff that were there as well, and there was a group from the administration, including Mr. Berard, some staff from DHR, and also the Chief Recovery Officer.
And who is the Chief Recovery Officer?
Doug Barnum.
Okay. And who was present on the VSEA side?
I was there. The president at the time, Amy Bertrand, was there. The unit chairs were there.
Which units?
I believe the executive branch units, with the exception of corrections.
Right.
We had Gretchen Naylor, the director of field services, was there. Our general counsel was there. So I remember.
And how did the meeting progress? Can you describe it for the board?
Sure. The meeting was basically the administration came in, said they wanted to discuss the issue. We presented the administration with a series of questions.
What kinds of questions did the VSEA ask the administration?
We asked what research or data the governor might have used to come to the conclusion that this policy had to be changed.
And what was the state's response to that question?
They were not aware of any research or data that the governor relied on.
Do you remember any other questions that the union asked about?
We asked if there was any evidence that that service to state employees had been harmed by the policy, the current policy.
And what was the administration's response to that?
They had no evidence of that.
Did VSEA ask any concrete questions about how the policy was going to be implemented?
Yes.
And what was the state's response to those questions?
For the most part, they responded that they had no information about how it would be implemented, that they were asked if they had a plan, and they said they did not yet have a plan, but they were eager to hear what our suggestions were.
what was the state of affairs at the conclusion of that meeting, if you remember?
Can you explain what you mean by state of affairs?
Sure. What did the union do then next in response to the information or lack of information that it received in that meeting?
I believe we sent a demand to bargain.
Right. I'm going to walk you through a couple of more documents then. If you can look at exhibit 22, which is the out-of-state employee guidance.
21.
We had some testimony this morning from Mr. Brown that this is connected to the Secretary's memo of October 3rd. So with that in mind, Steve, I'll point your attention to in general, this guidance given to out-of-state employees. Had VSEA seen any of this prior to the email to which this was attached?
No.
So let me move on then from there. Look, please, at exhibit 23.
Oops. There you go. Okay.
This exhibit and the exhibit 25, which was hyperlinked to it. Do you see the part here where there's some information about new guidance on hybrid work standards?
Yes.
Prior to October 14th, 2025, had the union seen any of the information about the limited exceptions that would be allowed?
No.
So at this point, having seen the exceptions requirement and the 3-day in-office requirement, how did those requirements comport with the union's understanding of the previously existing telework policy?
It didn't. We believe that this was not a decision that was made locally by a local supervisor or an appointing authority. It was made by the governor. We did not. It was an arbitrary decision around the number of days that you could request, which seemed to be inconsistent with the policy. It wasn't a case-by-case policy. And there was no argument or mention of how the current policy was inconsistent with the operation of the state. It focused on exceptions, in particular, focused on the reason someone was asking for an exception, and not on the question of whether that employee's remote work interfered with the operations of the state.
All right. Turn with me then to exhibit 29, if you will.
Oops. Okay.
What is exhibit 29?
It is a letter from VSEA's general counsel to the director of labor relations, John Berard. And it is our demand to bargain.
Looking at the third paragraph that begins with the words because, turn to the second sentence, starts in the third line, VSEA. Therefore, can you read that last sentence?
VSEA therefore demands that the state cease and desist and from implementing any such change, and that it notify affected employees accordingly.
Do you know whether the state responded to the union's demand to bargain?
Yes.
We turn with you to exhibit 33. What is exhibit 33?
This is Mr. Berard's response to our demand to bargain.
Looking at the second paragraph that starts with the words the state's position. Can you just read that to yourself to make sure you have it in your head? Have you read that?
I have.
In the portion where Mr. Berard says that the state has met its obligations when it negotiated the original telework agreement, does the VSEA agree with that assessment?
We don't.
Why not?
Because the policy is not consistent with the governor's mandate is not consistent with the policy. It's a decision that is being made by the governor, not by a local supervisor or appointing authority. It's a decision that is arbitrary and randomly picks the number of days you are required to report to the office. And it's not a case by case assessment, but most importantly, the administration made no argument that the policy prior to the mandate interfered with the operations of state government.
After receiving this denial of our request to bargain, what did the VSEA do?
Filed the ULP.
Can you tell me the date of the letter that you're looking at right there?
November 10th, 2025.
I would note for the record for the board that the ULP charge in this matter was filed on November 10th, 2025. To your knowledge, Steve, was the return to commute mandate implemented on December 1st as the state had indicated it would be?
It was.
Could we have a moment off the record?
Yep.
Yeah.
Do you want to?
The union has completed its direct examination of the witness and notes the time. The suggestion would be that we pick up with cross-examination of Mr. Howard first thing Monday morning.
That would be a reaction then.
There being no objection, we'll adjourn for today and reconvene.